She started as the
You're a
receptionist,
gambling person.
which is.
So
So we go and take the train, and I know you have a lot of.
Okay, so you're gonna, expand it, but you're gonna end up sharing.
Like all of your.
Everybody's here and what this is here.
So I'm gonna unmute and,
And then we don't.
Obviously, back in disputes. But actually, there's an attorney on here, so. Beautiful, and it's Jeff.
oh, did I unshare? Oh, yes, I did.
She's there, I mean.
Yeah.
Very, very big personality.
You know,
Not
he didn't
okay.
exactly say, right, they said that you're gonna do this is.
Yeah.
He laid out all these problems at the time. Judge Caller didn't go.
Wasn't sharing.
moving.
Yeah, I didn't know that. Yeah.
So like, we either have these, there, and like all these like
Okay.
sectors.
Yeah.
Have like enormous mansions.
Mm.
It was a very interesting. I've been there once.
New Orleans is like that.
Yes, 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 yes. Very much so.
I don't even know if it's segregated in Austin, because New Orleans is like, could be one street over, but it's not house.
No. There is some of that like in both like here in the city.
Mm.
Right. Closer you get to the county, there's more property space and like that kind of stuff, but then you get cities within Austin are very big, not like here.
I'll get people online.
Thank you all for being here today. This is our first family law cohort. And,
Speak up, Nancy, use your lawyer voice.
use my lawyer voice. I'm so glad you all could come today. This is our first family law cohort that we've decided to put together. We're trying to grow this program. In 2022 already, it'll be 2 years I've been here, we began a more robust family law program. We at MVLS, we never did have a family law attorney prior to November 2022 overseeing the program. I came in and the goal was to not only increase the number of clients we see and the panel of attorneys that serve these clients, but also to build a more solid educational program for our attorneys who do in fact volunteer. And one of the things we wanted to do is bring together, we did it a little bit through having our family law listserv for those who know about it. But what we were really trying to do is bring newer attorneys together with more experienced attorneys. And we thought this would be one way of doing that. The listserv goes so far, but meeting in person is even greater, I think, to be able to collaborate, to talk, and to change ideas and that sort of thing. So here we are. And I just want to give you a little bit more information about the family law cohort, how it's going to move along, and a little bit about the Judicare program, which I also oversee. The family law program entails representing underrepresented clients who otherwise couldn't afford or access family law legal help. And what we're trying to do in the family law program, we have contested cases and uncontested cases. The contested cases fall under the Judicare program. The Judicare program is a program that is available to experienced attorneys, and you are compensated for that work. An experienced attorney would be one who has at least 3 years of representing these types of clients, contested clients, or has at least 2 years of experience working with a identified experienced mentor. Who has practice. There's also those cases that, which I hate to say, Thomas will probably cringe, easier cases. Family law cases are never easy, but maybe they don't involve as much in a way as maybe there are many children, maybe there is some divorce, maybe there is something that's a little easier to navigate. Those are the types of clients that the mentees will be receiving to work with. They will not be Judicare clients. They may get complicated, that's why we have a mentor. The mentor is a person who you go to. I have not assigned the cases yet, but I will. I will in the next couple of weeks. Some a little later than others, but I'll try to get as many people with a case as soon as possible. Once you have that case, you want to connect with your mentor, right? And go over the generalities of the case and talk about your strategies. This is a 6-month program. Takes probably about 3 hours or so a month for 6 months. And I think you should really, really enjoy not only the aspect of learning how to represent a case, but certainly becoming more of an involved member of the family. And we have some wonderful volunteer attorneys. I will give you all access to the listserv. You will not be able to take a client off the listserv because I only post registered clients. But the purpose of that is so you can see the banter. You can see how we engage, how we share, what we do, and certainly ask questions if you have to. I'm always here. You know, I live at my computer. I have my phone in my hand all the time. I call back right away. If anybody needs me, feel free to contact me at any given time. Really, really. I think Curtis has called me late at night. Thomas calls me all night.
Only
That's
emails.
okay. It's all right. It's okay.
Only emails, huh?
And, but I'm always around. So don't hesitate to give me. All right, so now we're going to move on to our presentation. I'm going to share my screen with all of you, and we are going to get this set up. Hang on with me for a minute.
That's it.
Now, let me take a moment to introduce our speaker. Thomas Mulinazzi. I'm going to just introduce him with Nelson. Thomas is a family law attorney for many years, well respected in that community. He is going to be presenting to us the first training that we're providing today on the basics of family law. Thomas has been around a long time, right?
Unfortunately, I think.
Yes, I think that's about accurate, right? And Thomas is one of our best attorneys on our panel. He has a passion for pro bono. He has a passion for MVLS and the work we do. Thomas, are you still the president of the Howard Bar?
Nope, I'm a past president, so
Past One removed.
right, but
One removed. And
Still with
Thomas is certainly one we want to be here today because you will learn a tremendous amount from him. I've seen the presentation, fantastic. So without further waiting, let Thomas hit it.
Okay. And
You've got it.
I think Aaron's gonna figure out a way to make the mic work, and I'm just gonna elevate my voice still there.
Yeah, I don't know if this is supposed to sound like an actual microphone or if it's, but right. I don't know.
So I know some of you, and I know some of you really know what you're doing, more so than I do, so there's, I will try to use my best, I'm a former teacher, so try to use my best teacher techniques to read your face, like, yeah, I already know that, or, but just ask questions, and there's a lot of material I may have gone too broadly, but I thought that was the purpose, and Nancy or Aaron, great, we'll move back. So
Join this.
that's me, that's not really much important part. It is true that I have passion for working with MVLS. It's, well, I guess you guys are, you too, would be. So I'm supposed to give Nancy like a cue, go to the next
Yeah.
slide. I'm going to talk first generally about being a family law lawyer, because it will be very hard, but very rewarding. Hopefully I don't repeat myself. It is both equally very hard and very rewarding. Every day, you're working with good people at their worst. So you have to be empathetic and not sympathetic. Don't, well, we're all adults here. When I was first starting, one of my friends, his father was a family law attorney. He said, every time I sit down with a client, they take their own bag of shit and they try to put it in my lap. But I just push it back across the table to them and I say, that's your lap. I think that's, I don't know, that's a good visual for me, but you're helping them. But you know,
I'm gonna go see.
you don't wanna- so
Check it out.
when I talk about realistic expectations, every day, we're telling our client, this is Maryland law. These are the possible outcomes, but what you want is not, can't happen. Sorry. Every day, including on my drive here and the last consultation I had. But you can still help people. Is that fair, Wendy? I mean, if it might be too much of a downer, you can still do a lot for people, even though you have limitations. The law has limitations. So here's some of my things I think we can, would be tips. There are some handouts that kind of go along with this. I included a parable, it's an old Cherokee parable. In essence, when it comes to us or a client, keep them focused, keep your sanity. It talks about which wolf you're going to feed. You want the one who's realistic and who's going to do, who's not going to make this.
Yeah.
So, this is what I think are the basics of what you. Now, I learned after a little while, I should also have at least article of books and procedure, but you literally type in, what's that rule that says, about in Maryland? You know, I don't think it's natural language search, it's just a dummy search, but internet is, I know we all have JDs, we're all super smart. But you type that. And if you look in front of my associate, watch it working. This is what you need most of. So I don't want to undervalue anyone here. I don't know all of you, but I do know Jessica and Wendy and Jessica, and they've done this a lot. Find your people, ask them, we're all willing to help. And if you don't ask the question, am I the crazy one? At least once a week, the answer is yes. You are the crazy one. Because people are going to push that bag of shit into your lap. Sometimes it's opposing counsel. There's some of us out there who would just say it like it's true and see if you accept that. And I'll do that in court too. It's really fun. So I think those are the basic tools you need. I should tell you, this is Canva, and I've never done it before except for this weekend, so I'm really excited. Probably slightly inappropriate, but I don't know. Anyway, if it's messed up, first time, if you like it. Yeah, thanks for the reference to my age again. So I thought this was a good place to start because when you do consultations or you're doing, we'll do, and I know Jessica's firm does this, probably both Jessica. When we're at the courthouse, people come in, you give them 20 minutes, they're just vomiting their situation on you. You got to distill it down to what's the issue, how can I help you, how can the court help? So those are kind of the basics, but my wife decided when I wasn't looking that she was going to add these types of slides in, but I did get rid of most. So, but I also think that it's pretty accurate. Again, these are good people at their worst. Like, you know, you love someone, hate them. That's not healthy, but you're not thinking clearly. And one of my colleagues, Dr. Reddy, said, there's an African proverb that anger blows out the candle of the mind. Yeah, you're not thinking clearly. We need to be the ones who are rational. So if the case goes to court, approximately 98% of the cases settle. The question is, can you get them to settle soon before people spend too much emotional income and psychic income? This is the ADR chart. I always tell people that you have to get something from a mutual agreement, a court order. There's rarely unilateral action taken. Good thing. But please do this quickly. Of course, we should try to settle things out of court, but by the time they get to you, maybe that's not an option anymore. Although sometimes cases can slow down, build some trust, and we can get that done. So when you're on this side, less expensive. You're on this side, it's for you and your spouse, or you and your co-parent deciding without people's interference, help, support, etc. The further you go this way, you don't have any control anymore. By the time you get to a judge, the judge is going to decide. But along the way, well, not along the way. Most people know about mediation, whether or not there's an attorney in the background. Collaborative law is a whole different animal. It's really interesting. A lot of people, well, Wendy, Jessica know a lot about it. The very, very short version of it is, and they may disagree, it's like the natural evolution of mediation. These folks function like co-mediators. They have the mediation training, the basic collaborative training, and maybe even the advanced collaborative training. Everyone signs an agreement to not go to court. Now it's America. So these people, and I'm sorry for the heterosexual husband-wife thing, but it doesn't matter, spouse. These people can go to court if they want. But when we sign the agreement, we cannot, because we're basically co-mediators. So that builds some trust, keeps us on our best behavior, keeps us on mission, hopefully. But it's a great process, not for everyone. Just like mediation is not for everyone. Should be, but I'm not a fan of this one being in the diagram. I don't know how you feel, Wendy, because I feel like it's kind of subcategory of court, or it could just be kind of done at any time. But in any event, it gets more expensive the more involved. So, point being, which tool fits the situation best? You don't want to go hog wild, file things if it's not necessary. But in a lot of MVLS cases, it is, because there's usually a very big power inequality, power disparity. So now that could be adjusted as you go on, and sometimes the other side, the adverse party says, okay, well, can't we just settle this? Now that he or she has a lawyer, sure. But in any event, questions?
Are we ready?
I think so. All right, court process. There are some differences county to county. Sorry. So it's very important to know your county, and you should reach out to experienced family law lawyers who practice in that county. Ask the court staff. The 5 unified districts, the ones that have a family division, they have a dedicated family law coordinator. Other courts do as well, even though they're not the big 5. And you should probably develop a bit of a relationship with that person or persons, because it's sometimes hard to get. So, in general, you all probably know this, but if not, case, you file a complaint, you have to serve them, file an answer. Scheduling conferences are different in each county also, but the basics of scheduling conferences are to schedule court services, not the hearing. No evidence will be heard. Nothing goes on the record. Maybe a county or two that does put their scheduling conference on the record. I'm not aware of one, but I'm willing to float that out as a possibility. I don't see anyone.
Yeah.
So
The city did for a while. Do they still?
they did for a while, and they did the 1-hour-long conferences. Really push it settle. Yes, we know. Anyone else? 2 or 3 years ago.
2 years ago.
And then it's on the record. Do they? Although it's super fast.
Yeah.
So you're going to get a lot of different services depending on what the case needs. Custody case, they're going to require you to go to custody mediation. That's domestic violence. Plus, you can convince the magistrate or whomever's doing it really won't work. But you're going to go to There's also,
So can you just list the services in this context? What does that mean for somebody who doesn't practice family law?
Okay. Sure. So first and foremost, mediation, it's either custody mediation and or property. So if there's no children, if it's a hybrid case, if I can use that word, we'll still go to mediation, and some counties will, for example, Anne Arundel will send you to a custody mediator and a different property mediator, less mediation. Co-parenting classes. They're called parenting classes, but I always call them co-parenting classes. You get a visceral reaction from client parent because they think you're telling them how to parent. No, you're telling them, how do I co-parent with that fill in the blank person? I hate him, her, them, whatever. You have to stay focused. Then comes the court services. And then they lead day hearing, which we'll talk about briefly in a second. This is Latin for pending litigation. That litigation being the trial in the merits. PL hearing, usually done by a magistrate, sometimes county will allow. Montgomery County may, but probably not, but they have multiple day PL. It's designed to bring you back to the status quo, which I have defined in one of these. It's the last, I'll fill in the word, quasi-peaceable moment. I always draw a picture of not a smiley face or a frowny face, but a face with a, couldn't find that emoji, but when we were like, okay, who paid what, who cared for the child, children, etc. That's designed to reinstate that because it's been chaos. That's he, she, them told you to get the hell out. And then you started acting like a complete idiot because you're so bad. So the scheduling conference, if someone needs, request this, it will be scheduled. Each different county has their own timelines. Everyone tries to make the case time standards of the year. Yeah, at the scheduling conference, they'll also set in a settlement conference or a pretrial conference. The words are pretty much interchangeable. And that is a sit down with a retired judge or magistrate who will try to help you settle as much. Hence, they will be interactive, unlike mediation, where we're supposed to be, you know, let's talk about some ideas, what's most important to you. Some mediators are really, some will be too directive. How does that work? But the retired judges are there to tell you. Sometimes they'll caucus and bring you and your client in, yet they tell you you'll be full of it. There's no way that's going to happen. Sometimes you might get to say that to your client who has not listened to you. Then you know what you're doing. Tell them. Yes, and then you.
With the PL hearing, does the judge decide once the judge hears from both parties, whose obligation is going to be what? Or is it really up to the parties to concede to what the judge says?
The judge or magistrate does decide. I'm going to put a little bit of more detail to that. If it's a magistrate, they can't decide anything. They make findings of fact and recommendations to the judge after an adversarial evidentiary hearing, usually 3 hours. Sometimes you can request a longer period of time, usually granted. Some jurisdictions do allow for a day, Montgomery County, sometimes even more. So evidence, testimony, just like a regular trial in there. And the magistrate will usually not tell you right then and there, but they'll make a report and recommendation. You get it in the mail. Yeah. And you have 10 days to take exceptions, which is just like an appeal. This is all in Maryland Rule, Jessica, correct me if I'm wrong, 9-208, where it says what the magistrate's duties are and the procedure. So to take exceptions, the short of it is you have to order the transcript, and that's going to cost you something. You have to draft your exceptions, which is easier than writing an appeal. And then the court schedules an exceptions hearing. You go before a judge who is already thinking, why are you here? We all know Magistrate Schwartzman, formerly of Baltimore City, now with us, or who Magistrate Smith is brilliant, knows what she's doing. You already had a half day, a full day. And the, not quoting standard, but kind of how close that. Did he or she get it completely wrong in the law? Well, that's different. Or is there enough, there has to be substantial evidence that the magistrate put in, or it's in the transcript to show that the magistrate came up. The judge, I have no idea how the magistrate came up with this based on what was given to you. And I've only taken 20 years of practice. I've only taken maybe 4 or 5 exceptions. Usually I'm counter accepting because someone was dumb enough to file exception. Recently I found one just because the magistrate just forgot to address an issue, and I literally wrote, everything's great, you got it completely right, just the magistrate forgot to address this issue, up or down, I don't know, Your Honor. And that was a 5-minute.
And a retired judge as a magistrate, or?
Nancy, we're having some, people are getting fried by some extreme sunlight coming through one of those,
Oh, where's it?
I don't know.
You got it?
No, the magistrates are appointed full-time employees, they have their own courtrooms, they're there all the time. They're there so that they handle the caseload, so it all doesn't go up to the judges, and they're specialty area experts. So that's why, that's all they do all day long. Now, different types of family law, that's all they do. So they have extra training, and
I was asking about the retired judges. Are they treated like judges or as magistrates?
the retired judges, when they're in their role, when retired judges come as visiting judges, they're a judge. If whomever the settlement officer is, the magistrate or retired judge, will call her Your Honor, they can't make decisions here. Just helping you, twisting your arm to get you to settle some or all the issues.
Oh, I was gonna ask, when you go to the settlement conference, when's the one? But, if they had called me back, but they didn't want the client. So at what point does then you can judge first, and then you go back and do the client?
But each judge has his or her way of doing things, but most of them, bring in the 2 attorneys first, because we should not be emotional. We should be clear in our thinking. So when the judge says, well, what's going on? He's a son of a bitch, right? This shouldn't be. So the judge gets a good idea of what's happening. Even though they've read the pleading, sometimes the reality changes. You ask for alimony, it turns out your client actually makes $1.50. Because they weren't counting like these 3 other things for their bonuses. There's a slide. That almost always happens. Then let's call it the settlement officer would say, well, what do you think is the best way to go about this? And attorneys may say, hey, bring them all in, it's great. Or no, we should definitely caucus, keep them apart. They're awful together. Or one person fears the other, they both fear each other. So the settlement officer uses a lot of techniques in mediation. You understand what's going on, see if there's any small issues, maybe the big issues. Sometimes you have one issue that can be settled. Yeah, they both want to sell the house. Okay, let's put it on the record. But each settlement officer does it differently. Some judges keep in there for the full, sometimes 2 hours. They want to work some magic. And then some retired judges will say, okay, sounds like you're not going to settle. All right, well, you want to go get trial dates? You can try, but they might be right. Like they just face it. So you want to find out who your settlement officer is in advance. Talk to the opposing counsel in advance, see if there are any I'll call it low hanging fruit that we can settle on. Like, what's your goal for this? What do you think you get out of it? Nothing. Super, good talk. Okay, fine. You still have to show up. Maybe this one person didn't, but I assume. Yeah, and that's the thing about different courts. Sometimes I'll just say, move it to the next week. And I don't wonder why she'll call us. For the attorney, just automatically.
Well, the court sometimes, I guess, in your experience, move case or delay cases because they see that parties might be reconciling their own.
So they are under something called the domestic case time standards, and every divorce must be done within a year. So now custody is different, and they have people who are managing the schedule. So if you get a custody case, you go to get a trial date, and I'm thinking of a particular person who's a friend of mine, but she's Puerto Rican and she don't play. She's like, well, you're gonna get your date whenever you get your date because divorces come first. So they can't delay divorces beyond, well, the admin judge can do whatever he or she wants. But they're under pressure, there's money tied with it, to meeting the case time standards. So if you're at a settlement conference, a lot of places won't give you your trial until you're done with this. Because 98% of cases settle, no matter what. So they can't fill up their docket with stuff that's coming off. So I had one 2 weeks ago, and we already had one. You know what your case time standards? Let's say you're going to settlement conference tomorrow, but you know, filed it on February 1st. They're going to try to give you a date between now and then. If you're like, well, I want another settlement conference, maybe, but you're still going to get a trial date. It still will be done. And that's the good and the bad of taking it to court. What I mean is, when we work with people, our clients, sometimes they're just spinning their wheels. Like in mediation, they're just chatting with their spouse, and no knock on mediation. But sometimes it benefits one party to not resolve something. Sometimes it's my client. And this is not a big secret. I tell them delay. Because you're not working and he's shoveling money or she's shoveling money into 401k, right? And you're not working and he's paying down or she's paying down the house, double mortgage payments. Half of that equity is yours. What are you doing? You're making money right now, doing anything. That's not a big secret, right? You do it too. So someone's got to file because then you get on the court's timeline. They have a year to settle this. Now they're motivated. They have to go to this. You have to go to that. You mentioned the word reconcile. Sometimes they reconcile. I mean, got a couple recently, and literally a couple of cases. And file a joint line. I usually say they're reconciled. I want someone to smile. You don't want them to think it's awful because of coercion. Even the one I just. But that's what they want. Give it another shot. Leave it all on the field. So there's a lot here, and I in the materials, because it's going to be electronic, I provided Howard County, Montgomery County, Anne Arundel County, and Baltimore City scheduling orders, which will give you a little bit of flavor of what that looks like. That's the rules. I put the scheduling order in my pleadings folder. And yes, I did even my folder. Still have paper right here because you need to know what your deadlines are. You're going to get big one is your discovery deadline. Put that right in your calendar immediately with a reminder, 2 weeks, 4 weeks, etc. Issue discovery at least 30 days before the discovery deadline. I went like this to Wendy because she knows that's not a good idea. You need to do it a few months beforehand. After the 30 days, when they don't give you anything, then you send them the first good faith discovery letter, give them a little more time, must make another one because the rule requires you make good faith efforts before you file the motion.
That's fine. Take a phone call and enter on the account.
Right. Which, yeah. That was Judge Trumbull's rule. It's a good idea. Like, the court wants you to solve things. 98% of cases settle. And someone who works for the court once told me, if if this case goes to court, Thomas, that means one person is crazy. Tell my clients, it will not be me. I will work really hard to make it not you. If I can't do it, I might not be your lawyer at the end. And we'll try to behave ourselves so they don't act more crazy. So you really owe the judge an apology if you're not. And if you had 100 transcripts of my opening, half of them at least have an apology. Sorry, we're here. Because you should not take this all the way to trial. It's not right. Some people, some litigants, are crazy. Or they have substance abuse. Or whatever. Those have to go to trial. They're abusive, which is. So there's a lot here because every jurisdiction is slightly different. That's why you have to ask. There's certain things you can do in one district that you can't in another. I have a case with a Montgomery County attorney. He didn't realize that I could file a request for a conference call with the magistrate and actually get it. On the phone. Or emergency hearing, which will probably be an entire another seminar, are different in each county. Forever ago, when I worked in Baltimore City, and correct me if it's different, Jessica, my first job was with Sue German, who's no longer there, and I was the first one to look at the emergency request and give it to her. And she did the assessment. Then it went upstairs to the then special master. And the unofficial policy was, is there blood on the wall? But in Howard County, they'll give you an emergency hearing if you want to, your kids, if you're fighting over which 10 out of 10 grade school, elementary school your kid's going to go to, because they're just going to make the time, which is, but, okay, good. If they'll make the time. And then it falls in between. Anne Arundel County has an interesting policy that I think they still have. They may grant your petition for emergency hearing, have the hearing, and then deny that it's an emergency. Like, but you already ruled that it was enough of an emergency to have a hearing. That was a big show. Think? Oh, yes, sir.
The services, is that a time when the custody evaluation? That's
Great question, yes. And I even have a note here that to myself that I did not include anything about BIAs. I should have, but I promised you I would. Yes, those are some of the services. You can also get a substance abuse evaluation. It depends on which county. In Arundel County, they'll bring someone down with a test kit right then and there if someone's available. So that's kind of fun. But custody evaluators, each county has their own unit. Baltimore City has the whole adoption unit. They do home analysis, but they're have less resources. So good luck with that. Howard County used to have one social worker. Now we also have 3. We don't have to do it ourselves. Because it used to be we've never asked for one. Now they're asking us, are you sure you don't want one? Are you sure? Are you sure? So it's a little weird. And then BIAs can be appointed. The way it works in Howard County, and I like the way it works, that's why I'm using it. The 2 attorneys, like I'll call you up and I'll say, what do you think about using a BIA? I'll tell you about it. Well, there's a couple independent questions. Do you agree? It's a yes or no. Regardless of that, you have a few names that we can agree on just in case it's granted even though you don't want it. And do you agree to split it 50-50 or some other proportion? Independent questions. So when I file a motion for requesting a best interest attorney, I'm going to say the opposing counsel disagrees. The opposing counsel and I agree if Your Honor does, it could be one of these 3 people, etc. The statute, I think it's 9-2 for the BI. There's a Maryland statute that says what the factors are. It's right there. Every case is not going to meet all the factors. But basically, if the children in the middle, there's danger to them, there's mental health professionals involved, there's CPS or DSS involved, a lot of disparagement, suicidal ideation, cetera, some extreme situations. You want to get someone in there on the ground. And I could talk for hours on the difference between custody evaluation and BIA, but the basic, in my opinion, is that, and there are some people in this room that do BIA work also just like me, is that you get someone there immediately. So the custody evaluator has his or her schedule of the home visits, or talk to collaterals when they can. Okay. But the BIA is like emergency response. I get a call, you know, little Johnny, this or that, I drive. And BIA work is different than representing adults. So you will work off hours. You get to go to school, you get to talk. Everyone has to talk to you because you're the legal adult embodiment of that child, to include the children's therapist. You're the only one that gets to know, unless you waive the privilege. Some therapists don't like that. Some people fight me. But usually a letter about how you call your deposition ends that. We're on the same side, but it's, you learn what's going on. You get in there. Your first job is to protect the child, keep him or her out of the middle, gather information. Your only client is the child, so you're against both parents and both attorneys. So it's not a job for the weak, but it's really helpful. And you should be able to settle a custody case because you're going to say, here's what I see, here's my information. And if you don't like it, then it'll be 2 against 1. And you and I have had a case a long time ago because one person was crazy. It did end up being 2 on 1. Like, you're already crazy. Now you're going 2 on 1, 2 on 1 crazy. I think after this, I think we have to go.
At what stage can you request the BIA? So at the scheduling conference?
Any stage. However, at some point, it's really too late. Logistically.
But twice, so I'm a BIA as well. I've been appointed twice mid-trial. So sometimes like trials, like 2 days in and the judge is like, we need to know what's actually going on here. And then they appoint me and I have to figure out like what to do. You know,
They
typically I help
continue
settle
the
the
trial.
case. They continue the trial and then I have to rely on the good graces, order the transcript to know what happened on days 1 and 2 and then come in. And
Yeah, thank
so
you.
that happens every, Judge Glass in Baltimore County does that.
Thank you. That's a great point because when I was thinking to tell you how BIAs come about, it is obviously by filing a motion, but sometimes good jurists, such as the magistrate, say, come to trial.
I'm appointed several times in appeal hearing. It's not uncommon.
And that's good.
Yeah, no.
Beach it.
Yeah, the magistrate.
Let's go. Why? Let's go into that. Sit down. Why isn't there BIAs? Got to, you know, and, oh, yeah. So can you all agree to one? Because I'm an appointed one.
There's also times where you're appointed as the privileged at trial or at, you know, hearing today, or even a settlement conference where they'll say, well, we need a full-blown BIA, not just. Or is there privilege?
I'm just reading your face. So privileged attorneys only
I was going there.
only appointed to talk, find out if the privilege the child has with mental health professional, could be therapist, could be a guidance counselor, maybe a doctor, as long as they're confidential communications, whether or not those people can testify, because then you'd have to waive the privilege permanently. Otherwise, the privilege exists. There's been lots of chatter on the listserv about that. Bottom line, judges do not want you to involve the children, do not want you to invade their privacy, sure as hell don't want you to invade their privacy with their therapeutic and or medical records. Not at all. So you can do your fancy lawyering and your hearsay stuff and this and that, and you're going to get a lot of pushback, make an enemy of the judge, and good luck with that. So,
And it's grievable.
So we're supposed to protect the best interests of the children, part of our duty in the custody case. And we should. They're usually the innocent victims. So
Oh.
So here's the different kinds of family law cases. That's just an outline of what's to come. So, Nancy, go to the next slide. Divorce has become easier. So it's all no fault now. Bottom line, you can't have a mutual consent unless there's a signed agreement that covers everything. So when we do MVLS cases, you may find an agreement, take a look at it, probably not complete, might be due to coercion. I had a guy come in with a one-page thing that he handwrote, excuse me, she signed off, she doesn't speak English. And like, I am not going forward on this. So that was fun. It ended up okay. So that is rare. And if you get this and it's done right, you're done. I mean, you need to do an uncontested, but, so I don't think we really need to talk about this too much. These two are the ones in orange are the only two remaining viable grounds for divorce. And every magistrate and judge has a different definition. So here's the bottom line. You want a divorce, courts, the legislature said, let it go. Green light, do it. So these definitions that I put in blue are not even, magistrate might agree with it, or they might look their own separate lives in or outside of the house. Because people can't afford to live separate. Some people. How do you define that? There's all these things you could say, but they don't have to meet every single criterion. Like, do you have separate bank accounts? Do you eat together? Do you grocery shop together? Do you do her laundry? Probably, but they're just not making eye contact. I'm not gonna talk to you. Ships in the night. Okay, fine, whatever. You want a divorce, that's fine. But I have a couple of these who are coming up on a year and they're still in the same house. They're trying to sell it. Awful. Who would want to live? You already hate each other. Now, one of you filed for divorce, the other filed a counterclaim, you make all these allegations. Awful. You're allowed to do it. Irreconcilable differences. I mean, yeah. Yeah, you wouldn't have filed. Don't do this. Just don't. I have done 2 annulments in my time because in both cases it was a man who was already married, got married again. Okay, yeah, we get an annulment for that. Other than that, no, you're gonna hear, well, we went to Vegas and then we never consummated. Yes, you did. I don't want to know about that. You're probably too drunk.
I got one on fraud last year.
Fraud?
Yes, I did.
What kind of fraud?
It was pretty bad. He like lied to her and
Yeah.
like evading
Very.
tax stuff and had like federal criminal charges and things against him
Did it work?
in Anne Arundel County.
Some counties are, more traditional. But some people will come in and tell you,
There
well,
was more to it than that,
Okay.
Thomas.
I didn't realize that he was bisexual. I didn't realize that she wasn't gonna have sex. Here's why. You can just file for divorce. Like, you have relief available to you. Don't do this.
So there is an element of violence and abuse. These are the options.
Yes, and what you do with that, element of violence, abuse, et cetera, financial coercion, it used to be a ground rule. And now it remains a factor in the amount of alimony you can get, remains a factor in the amount of monetary you're at. You could get more than 50% of the asset. Not to talk too much about asset stuff because we're doing MVLS. But we can all talk offline. Ready for the next one.
Quick question.
Oh.
In the event of
There you go.
domestic violence or like serious issues, will the court expedite the seizures?
So, different topic. If there is domestic violence, there's other relief, like petition for protection from domestic violence, which should be filed. Probably even as close, because after hours, you can go to the commissioner. That's called an interim protective order. During hours, you can go to the circuit or district, get a temporary protective order. And in 7 days, you'll have a fine. Both of those are perfect. Then you get a final protective order 7 days later, or a little bit longer if something like the DSS investigated. But that, as the petitioner, you need to prove abuse or a threat of abuse such that it puts you in serious, evidence fear serious bodily harm. but there's also stalking, harassment, revenge porn. There's things you would assume should be there. And there's pro se forms for that, and you can see the boxes that you checked. And it's now, in this preponderance of the evidence that the abuse occurred, needs to be clear and convincing. So in order to protect the victim, and it usually lasts a year and lasts long, while hopefully there's victim side, move him or herself from marriage, divorce is going on. So you have that order, which can grant certainly a stay away, sometimes emergency family maintenance, and custody temporarily, while that goes on. But it's hard to make that argument to a circuit court if you're not asking, didn't file for the final. Sometimes if you're the respondent, you either signed up for consent, FPO, have to go through it, or you feel like you got a bum deal, you can ask for an expedited PL so that, because the circuit court PL order on custody will supersede. That's just a Band-Aid. That sounds harsh, but hopefully it's given protection to the victim. But it's not meant to settle everything. Family, it's meant to protect. So that's a whole nother discussion we can have. Hope I didn't sell that short. A lot of that order. It's very important. Okay, so alimony. You can see 3 kinds. And then they lead to alimony. And I gave you the alimony factors. There's 11, I think, factors to alimony. Just like custody factors, some are more important in your case than others. But at PL, only 2 matter. Only 2. I highlighted them. That is, give me a break, I'll use traditional generalism. His ability to pay after he pays his expenses and her need. So it's income and expenses. That's it. Now expenses, if you get to fight about that, do is theirs. So are the expenses necessary and are they reasonably priced? We say reasonable. In certain areas of the state, your apartment at $3,000 is reasonable. It is. You know, groceries being what they are, or gas, whatever. But it's usually the status quo. Like, what were the expenses when you were okay together? I have a client who's going to court, and when they sold the house, hey, money, okay, fine, great, so far so good. She moved into a $3,000 apartment in the Meriwether district, and he has to live in the Marysville High School district, which does not have, low income housing. So they're both paying $3,200 a month for their rents, really. Because they're one child married to high school, and that's okay. Reasonable under the circumstances. But so let's say it's the husband. Gross income, subtract your taxes. Child support, if that's an issue, your reasonable expenses, do you have anything left? Years ago, this was Master Patrick. And I went into a hearing and she said, this is an alimony case, and she took both long forms, which we'll talk about in a second. She went to the very back page where it's income subtract expenses equals your surplus or your deficit. And she said, well, Thomas, your guy has an $1,800 surplus, and Colby, your lady needs $1,500. We're really having a hearing on this? I'm not. I can't tell you what we offered because that wasn't right, but probably have the numbers. The other person, no, we're not having a hearing. Okay. But usually we get into the financial statements. This is exaggerated. Because it is. That's the first thing I do with my own client. Highlighter. I print it with a highlighter.
You don't red pen it like a teacher?
I feel, because I was told red pen is impressive. You should see how hard I pushed down on the highway. And then you do the same thing the other side. But, so PL alimony is just meant to settle the waters pending the trial. 8 months, 6 months, used to be crazy, it could be really, really long. So then the merits alimony is different, but we're talking about how much for how long? PL, that until the trial. So, I think it's another slide. I think there is about that. Let me just, beep, you want me to do that?
Did you want me to do
No,
that?
no, I'm just kidding. So that's the PL alimony. This is the definition of the status quo, which I pulled out of the case file. There is a long form financial statement in your packet. It must be filed. Anyone at either side asks for alimony, it must be filed. So if either side's asking for it. And then the form is, in fact, the form's in the statute. Just do your best, but there will be another long form. So when you first file for alimony, you have to file this. I'll even write initial, word initial, next to financial statement. File it, because it will change, especially if they're living together. You don't know what her or his expenses will be. And you have to file another one before the PL hearing, so that the magistrate can look and say, oh, there's a problem here. And then you, according to the schedule order, according to the schedule order, you must file that one before the marriage hearing. Actually, sorry, before settlement conference. Should file one before the marriage hearing, unless you say we're adopting that. We can go on to the next one.
Okay.
So the difference is, and I'm summarizing the factors between the court favors rehabilitative outcome. Indefinite is unusual, and indefinite is not permanent. Some jurisdictions like Montgomery County like indefinite, and then you might be coming back in a couple. Sometimes in chambers, like, we'll just come back into you. Okay. But how, so when I have clients, I tell them during the pendency of the litigation, everyone wants you to be self-supporting. You too, Al. So what's your plan? Let's talk about a plan. We can hook you up with a vocational expert, career development person, whatever, because you have all this time to reinvent yourself. I know it stinks, but one of my mentors, Judge Chris Panos, used to say, life is what happens on the way to your plans. I'm sorry. You know, you're not married anymore. You're not a dual income household. You're gonna have to. I can't. Here's your bag of shit. I can't help you with that. I mean, maybe you get remarried. I don't know. But so what's your education? What are your interests? And I have had luck with having a vocational expert help people with career counseling. It's hard. I know, I used to do it at University of Maryland Law School. Yeah, I hear you. Not sure I did. So, how long do you need to rehabilitate yourself? You can get teaching degree, nursing, medical coding, astronaut. There's a certain time limit, and it's up to the person, the adult, to look into it and see how long she needs. Because that will be, when you go to court, you're telling the judge, well, first you tell the other side, you talk to me, you go to settlement conference. The settlement judge says, yeah, that's reasonable. Married 7, 8 years. Let's say he needs 3 years. Didn't finish college. Needs 3 years to get this degree and whatever, and then make 80,000. He's not rich, but he's self-supporting. Needs 3 years. So, or she raising these kids the whole time, staying out, because you have 3 kids, and she just needs 3 more years to get, she wants to go into nursing. Sorry to be stereotypical. And in 3 years, she'll have a degree, and she'll make 80, she wants to go in nursing room, she'll make 100. Okay, then you're done. So, I wrote, what's the plan? Because you have to have a plan. You show up at trial, and you still need alimony. I tell my clients, you have to have a plan and be working on the plan, or you started your plan. So if you have prerequisites before you can go into nursing school, actually, taking biology 101, anatomy, or whatever she needs, yeah, yes, Your Honor. Okay. Indefinite alimony is probably makes sense for our older clients. Problem is when you get clients that age range. I don't know when you think the age range is. I guess it depends. But even I think 45 is still pretty young. You could reinvent yourself, but you start putting a 5 in front of your age. You can reinvent yourself. You can. But how much money will you make? I have one case right now. They're both in their 80s, both terminally ill, and the other side is fighting me for alimony. It does not work. Okay, we're doing her estate plan because, I mean, okay, awesome. File the long forms. I mean, I'm not telling you who it is, obviously, so I can say this. I don't know if they'll both be alive by the time this. That's not likely. But they asked for alimony. They filed their long form to go along with this. One side currently is crazy. Now this one is tough. If you have someone who's self-supporting, let's say he makes $100,000. Good money. You don't get to fly around the world with that, but and then she's crushing it as a vice president of T. Rowe Price. Real case. Makes $700,000. My guy could make, according to their expert, 130, according to our expert, 80, self-support. They weren't married long enough, but case law says you can't get rehabilitative alimony with this factor. But we see clients who, especially women, given their entire life to raising a family, taking care of the family, doing all the stuff that's very valuable, but is not monetized. 20 years later, I've just talked to a friend in the lobby of our building, and he's in his mid-50s. I'm seeing all my friends, they're empty nesters now, and husband and wife turn to each other and they're like, I don't really like you. Just staying together. So then they break up. Well, maybe she did all this work, raising 2, 3, 4, 8 kids, president of the PTA, just crushing it, a superstar in all ways except for the way society pays her money. And then he's like, I'm leaving. Hey, my buddies are going Southeast Asia. Up to no good. Okay. Well, he makes, so that's going to be, should be indefinite alimony because of age, education, and a lot of people that have, there's all these amazing women who have these great degrees from 1980, 1995, 2001. We're not hiring someone like that until they get re-educated.
With long marriage.
Yeah, I think that's a matter of opinion.
Yeah, that's a great question.
What's your long
Definitely
marriage?
30, definitely 20,
20.
and then below that. There are alimony guidelines. I don't use them. I have them on one computer.
Clarify that statement though. So there are child support guidelines that are mandatory.
Right.
There are alimony guidelines that we use as like gut checks and we can argue to the court, but are not binding.
Right. And they,
Important distinction.
there's certain data inputs you put into the alimony guidelines that you can't put, they're quantifiable, but they're not qualified. There's no quality to it. Not, you can say who was the primary caregiver, but you can't say, and he had a gambling problem, and I forgave him 8 times for cheating, and he tripped, hit on my mother. Like, it's just not in there. I mean, these are real.
But you can put the number of years there.
He's not as bitter as he sounds, I promise.
So-
And it is very, very rewarding work. Thomas makes it sound like it is awful, but it is very rewarding.
I almost quit law school a million times until Professor Janice Singer saved me and sent me over to the Baltimore City Circuit Court to intern for Sue German because I was bored out of my mind. You will never be bored with family law. Never. And you were always helping someone who really needs it. I have built a tribe, and I can walk into any grocery store in the county and not have to worry about it. Someone's going to kick my ass. So, except for the other side. So what's a long marriage? It depends. And sometimes we get these cases where they're married a second time. In their sixties or late fifties. They've only been married for 10 years. You're not gonna ever be self-supporting. But then usually, say it's the guy, he plans on retiring soon anyway. But that's why it's indefinite, because it's not forever. So that's why I'm telling those obligor spouses, you get hurt, or your industry changes, and you don't have an industry anymore. But through no fault of your own, you apply to modify, decrease. I had one guy do it, called me up, and then I think he may have he may not be doing so well, but he's one of those happy his faculties are not as they used to be, but he's happy about it. He's wearing only skivvies in the Zoom settlement conference. He got up and like, whoa. So, he's just at home. He's not working anymore. At least he weren't. So, I don't know what the answer is, but
Alimony's a hard one. There's not a lot of direction out there when it comes to that. I mean, alimony is very, very hard. You don't know who your judge is gonna be until that settlement conference, or sometimes don't even know until the night before, right?
if you have a good settlement judge, he or she can tell you, hey, let's get it. I think this is an indefinite out.
Yeah.
Why don't you settle for blank? And then there's something called step down alimony, which is I'm gonna keep going back and forth with generals. She pays him $5,000 for alimony for 3 years, and then $2,000 for another 3 years. Alimony's hard, and there's not going to be a lot of alimony cases, less cases. We could be recipients, but usually the spouses don't make enough money to pay. But I have Baltimore City gave me $250 a month from this bus driver guy because he just could not stop. And Judge Shar was like, oh, okay. $250 for 5 years. He was really upset about that.
Next.
I don't know.
There you go.
All day.
So there won't be a lot of these property cases in MVLS, but the basics of it are, and this is my little thing, feel free to steal it if you like it. Every once in a while, give me a shot. So again, this is heterosexual based, I'm sorry. You could just change the colors and it'll work. So if you're the guy and she's the lady, before marriage, that's your own stuff. You're blue, she's pink, so what I'm thinking of the game life. You get married, your paycheck is purple. Buy a car, it's purple. You don't know it's purple because it's marital. Marital property acquired during the marriage, regardless of title. You're gonna get a lot of men who say, that's my pension. No, it is not. My 401k, that's my car. And I'm really happy to report that female clients I have who do really well financially do the same awful bullshit. So good for them. I guess the word's not misogynistic, but is it chauvinist? That still works. Sure, that's my money. It's your money. I'll hold up my purple marker over and over again in their face because it dumbs it down and makes it easier for them to understand. Sometimes you have property that I bought a house before marriage. How much did you put down? Nothing. BA. And then you got married 3 months later. Your blue equity is like nothing. I keep telling them, purple, half of that is blue, buddy. So slow your roll. You're gonna get half. I had a consult yesterday with a man who kept saying, so I'm getting nothing. Nothing. Or you're getting half. More than nothing. What's wrong with you? Anyway, of course, when they get divorced, now there are exceptions, which are down here. Probably assumed it was inheritance and gift. You're absolutely right. If there's an agreement, sometimes they both went to the expensive apartments. They sold the house, split it in half, and agreed that's her money, that's mine. Okay, that's off the table. It's over here, not part of the marital assets. What has to be filed. This is deep water. Interesting, but That's why mediation is so important, gesturing to Wendy, because she's an excellent mediator. And so try to work it out outside of court. It's just one more step to trace. So is the business marital? I have a couple cases right now where the business is marital and it owns a piece of real property. So if it's a halfway reasonable attorney on the other side, you agree the property is marital because the business is marital or purple. And then you have to worry about how are you going to value it? Are you going to value the business with or without the property? I have one case right now where there's a business they set up, it has a bank account and a property. That's it. Like there's nothing to it. But it's often more complicated than that. But you won't have that problem with MVLS cases because you shouldn't, because they're really not supposed to qualify for services. They have all sorts of different. And you all can tell people what you want us to do when we find that out. What is-
I'll answer that, I guess, but I was gonna ask another question. I mean, I would say, just reach back out to MVLS, whoever was the advocate that sent the case over to you, their email address and name on there, let them know if something like that comes up, and then we'll look into, does this person qualify for MVLS, or what do we need to do? But I was gonna ask a question, Thomas, because we get people a lot of times where they may have done a pro se divorce, they didn't deal with the property at all, and then they come back to MVLS and they're like, well, there's this house, I want to get it in my name or whatever. Like, what's the process there?
So-
Like, for you guys?
I'm answering the question with my facial expression. That's not fair. Depends on the facts. So once you're divorced, you now have anything you have, you're a dude, that's yours. And
Assuming
that's
it's
yours.
individually titled.
But I hear you, I appreciate that. So if you put the house in your name only, because you're that kind of misogynist, and then you coerce her to get a divorce or she shouldn't have signed anything. House.
Okay, even if it was bought during the marriage.
Because you're not married anymore.
Once it was bought during the marriage and you divorced and it's just in your name,
And
now
that
it's
was
your
your
house.
time during the
Okay.
divorce to fight it.
Okay.
Disagree?
The short answer is the court can't go back and deal with marital property post-divorce.
Okay.
I think that's the real answer I think
Right.
you're looking for, right?
That's the good.
That's the short answer.
I don't actually know the answer. I'm
Oh,
really
yeah,
asking.
Get the short
Calls and I don't
answer.
know. Yeah.
I
yeah.
agree with Jessica, but
Uh-huh.
the face she's making tells me that she might face differently, but you agree.
I do. What's the 90-day? I'm trying to. just remember what
So
the
the court, so what you're referring to, Wendy, is under the marital property statute, right? And correct me if I'm wrong, Thomas, the court has the authority, the court only has the authority if they elect to do so in the judgment of divorce to reserve on ruling on the marital property issues for 90 days post judgment of divorce. But if they do not explicitly reserve on it, you lose it. Yeah.
Or 91 days.
So
Or
what?
91 days passes.
That's
That
how
also sometimes happens. They screw up and the judge forgets to issue a subsequent order.
What if
it's
it's
not
titled in both of their names?
Right. So then it'd just be like if you and I bought a house right now.
So it,
Same
it becomes like tenants and commons once they
Yeah,
divorce.
right, breaks immediately
Yeah.
upon entry.
You have to file a request to for sale, new partition, and
But it has nothing to do with the divorce court. Like, you're not going back to the divorce court about
Yes.
it at that time. Yeah.
yeah,
Okay.
it's just two people who aren't married, just
Mhm.
like if you and I bought a house right now,
Mhm.
next week. Like, pressure me in front of all those people. So you want to sell it.
Mhm.
That's why now is the time during the divorce litigation. That's why you have to discover everything.
Yeah.
And there's some folks out there that I got this one guy who currently buys houses in his business name, which is actually marital. Doesn't tell her, and tries to sell it. But so now we have to find it. So you look on land records, you look all over the place. Some people aren't going to tell you, and then file these pendants. Everyone's on notice, but then some title people, companies don't look. Do a TRO. We'll talk about all that later. Luckily, almost all the cases from MVLS don't have that.
A little bit of a lot of it.
Right, and that's what one of the things I like about it. You have to learn about various things. Right now, I have a client on the way up, reading that, you can learn all about the credit card processing.
Some of the problems that we see are clients who come to us, and I mean, they are really down and out, you know, homeless in some cases. I could think of a woman who was in this situation, husband leaves, she has nothing, she never worked, she's disabled. But he has assets, you know, all kinds of assets. So the client comes to us and she is so poor, she cannot afford a dime. But we can't take her because the assets that she's entitled to,
Oh, just qualify.
she's qualified, and therefore that is beyond and above
Want my
the
answer?
eligibility piece of this.
Send her to Thomas
And what will Thomas do for us?
for a motion for attorney's fees up front.
Right, that's what we would do, and it's, very likely in a number of counties and not in others. Your first normal course bite of the apple would be your PL hearing. You can make it that long. But you can file a motion for immediate attorney's fees and, can also file motions for restraining orders so that assets can't be sold off, dissipated, et cetera. Big pain in the butt though.
Yeah.
And,
Pay off is worth it.
yeah, it's,
It is usually worth it. If you can't tell, I've litigated many, many cases with Thomas. And in fact, he mentored me when I was first starting in family law. So
Wow.
he's a good person.
Quick question. So with the motion for attorney's fees and MVLS, like I understand that we might have to get records and things like that. Do we file a motion for attorney's fees so that way those fees are paid by like the other side, like early on in the case, or how do we address any issues there?
so if I go fast enough, it'll be the last substantive slide.
Okay.
But, yes, you file a motion, yes, you make your argument, yes, you should provide documentation of his or her assets, client versus the other side to show the disparity in the need. And we'll get to it on the slide. There has to be a statutory.
How would filing for attorney fees without MVLS help? We don't have attorney fees pro bono.
Well, luckily, the case law, specifically Henriquez, which is also on the 2010, it's also on the slide, allows for that. Now, different judges have different opinions. And MVLS is working hard, some of us are working hard to educate the judges on that, because there are lots of situations where clients need to have some access to funds, and if their spouse has those funds, it would be purple. Everything in, let's say, his bank account. Okay, that's hers too. But they're hogging money, and they hire some fancy big firms that they're gonna bombard you with discovery. Okay. And actually, when that person does that, let's say it's a husband, he hires, I don't know, give me a name, Sam Brown from Anne Arundel or anyone else. I mean, not even that, but let's not. Then you put it in your motion. And you're like, look, write it in English. And she hired so-and-so, you know, PLA Piper to represent her. And the judge was, oh, because you have, the playing field has to be level. Family court is a court of equity or fairness. That doesn't mean 50-50, that doesn't mean exact, but that's just completely wrong, right? So usually that's successful. It's a little harder in certain jurisdictions. And it depends which judge is the motions judge, which is why you want to know the court and call up the coordinator and you say, how would you want me to do this? They can't give me legal advice, but what's the best way? How does the court want me to fashion this? Then you're like, oh, who's the duty judge this week? Just by the by. But I think it's better. Wendy, are you getting any fees in these types of cases?
I don't know if I've tried either. My question for these types of cases, would it be more accurate if maybe we're not getting attorney's fees per se, but we need like records depositions, like we need M&T bank records. M&T says, okay, I'll give you the records, but it's going to cost $100. Then who pays that $100? I feel like then it should be the purple
I wanted to make sure too that, because we do have some new people here, that so if you're taking a case from MVLS, you have access to the litigation fund through Pro Bono Resource Center, and they will cover those
Oh, that's
kinds of costs. So it's just an online form you fill out, you know, tell them what the cost is, you do probably have to provide a receipt or an invoice or something, and then they'll
Yeah,
cover it.
I've gotten money back.
That's fantastic.
Yeah, I've gotten money back from them. for
They usually do,
costs, And they're normally
yeah,
pretty quick. and
pretty
they just
quick.
Direct deposit it right into your escrow account and everything. Like
Question.
MVLS.
Yeah,
So,
it's
but
it's
after
good,
they-
it's
if
good
they are-
service.
are
Yeah.
awarded, that go back to MVLS.
I think that it does say that in the
I think it
judiciary
does.
contract, yes. if you're in
What
the
was that,
judiciary-
Margaret?
If they're awarded fees, that typically the fees come back to MVLS if someone's awarded it.
Yeah.
I think it says that in the
What I've
judiciary.
done in the past is just ask them.
If whoever assigned your case doesn't know the answer, they'll get the answer.
No, it does, it says, that's what I'm trying to say, it says.
Oh,
right, correct.
Or yours.
Right, right, but I think the fees and then the costs are like two different things, and the costs are covered by the litigation.
And I'll only say this, you all have been very generous when it comes to situations where we're way beyond the hours. If it's a judicare.
Yeah, I think we would be reasonable about that. I mean, we pay for judicare for up to 35 hours, so I think if you've incurred costs above that and they give you attorney's fees, then great, you know, I support you.
Right. The big boss will make that decision. Yeah.
Yeah.
But it's helpful because it puts the other side, it equalizes the playing field, puts the other side realizes, oh, this is how it's gonna be. Which, by the way, I should have said, when it comes to the PL process of, as divorce goes on, one of the unwritten things, phrase it better, one of the natural consequences that the court is very aware of, the outcome of the PL puts people, gives them a reality check. It's very likely that the merits result will be very similar. It's not exactly the same legal standard, but it's very likely the results will be the same. So you have a guy's like, I'm gonna get 50-50 because those kids are equally mine. Like, that's not how it works. We'll get to that in custody. Yes, they are. It doesn't mean you get 50% of the time because you work in DC and you leave at 5:30 and you get back at 6:30. And then, you are in a fantasy football league and you've got, you don't get. So it puts them on notice as to what's probably going to happen. We will not find that in case of ours. Okay, so it says what it says. So if anyone has hired childcare, or you've ever hired a housekeeper, or hired a bookkeeper, an accountant, you know that what she's doing at home. My dad used to call my mom the house manager. That person's busting their butt. I stayed home with our daughter the first 3 months, our first child, and I was like, please let me go back to work. Oh, thank you. So, I mean, you don't get to say, I made all the money. Really? Don't say things like, did she like laugh at your dumb jokes, listen to your dumb stories, and it makes you look better at your boss? No, she didn't know that. So what? The judge is not going to listen to that nonsense at all, especially now that it's all no fault. I'm going to talk about it for alimony or monetary work. Again, probably wasting your time. Really extreme. By way of analogy, when adultery was a ground for divorce, I would tell clients, unless he is having sex with your sister or your mom, maybe your best friend, who gives a shit? You're getting divorced. Time to move on. You don't want to be with them anyway. So similar with the money thing. Now, if there's a big gambling problem or a drug problem, then you have to get into the accounting. Technically, half of that was his gambling anyway. But this is not the focus of our, because it's MVLS case.
Yeah.
So.
Beep.
All right, now the good stuff. So children they're difficult to share. Judge Jackson in Prince George's County, who hated family law, brought myself and David Coaxon in those chambers. Look, you guys can do your song and dance for 2 days, 3 days, 5 days, I don't care. And I'm going to tell you he or she gets the children, splitting everything in half, unless someone's getting the crap beat out of them, I don't care. And I'm gonna be done my ruling in 15 minutes. We went out the hallway like, here's the disabilities, what just happened there? But people battle because they have lots of reasons. They love their kids, of course. Also, that's part of their identity, father and a mother. I'm not a good mother if I don't have primary custody. That's not true. You're a good mother based on what you do and how you love your kids. The same thing with the dad. I need to have 50%. Why? If you work in DC or you travel a lot, you just can't. That's fine. That's fine. That's what you guys did. Now the hard part is when you lose, let's say your guy works his ass off. You lose your wife, she files for divorce, but you lose your wife. You're not going to get it back because you messed that up already. Two to tango, but you mess that up. So they decide to focus on their kids and make some changes. That's wonderful for the kids, but the wife is like, what? Are you super dad now? Maybe. Let's see. If he is, good for your kids. If he really is, that's hard because that's not what she's used to. But he also has to focus more on herself in other ways, like getting a plan. He should probably pay more attention to his children. Maybe he can be friends with his wife. But that's hard. You're doing a lot of psychology in this job. So you have a sheet with all the custody factors. That's kind of everything in the kitchen sink. Each case is different. So each case, you need what is important in this case. Like, again, he may be the best dad in the world, except he's not around a lot because he has a job. Maybe he's in a skip. Maybe he's serving our country as a civilian in war zones. That just is what it is. Maybe they live too far away. Someone's going to ask me what's too far, and I'm going to say, I don't know. It depends. It all depends on your tolerance. I live 7 minutes away from my office. Like, this was a journey. I used to do it every day. But it's all about from the children's perspective. And each of your clients is not going to see it that way when you educate them. A lot of clients will say, well, it's just an hour drive. Yeah, well, the kids should not have to be in your car for an hour to get to second grade. That's right. That's your kid, and I guess they should, because that's my time. I get to talk to them. Okay, that's a great story. Yeah, sometimes, but 10 times a week? That's nuts. A friend of mine's dad once said, Thomas, don't work in DC. Here's why. I spend an hour to get to DC. Follow me with the math, Thomas. Come back. That's 2 hours, isn't it? Yes. 5 days a week. Are we up to 10? Yes, we are. And if there's 4 weeks in a month, and that's 40 hours a week I spend commuting. I give my employer 1 extra week a month just to get there.
Wow.
So 2 kinds of custody, and we're gonna. Can you go to the next slide? I think that's well understood. Again, from now try to judge Panos, because you have 2 parents who hate each other. Which one is going to put down their guns and focus on the kid? Because that's the one who's probably going to get more time. That's the least unhealthy parent, or healthy parent if you have kids. Next slide, please. Okay. So let's start with legal. That's a little bit easier. Big decisions, we say there's 4 groups: medical, education, religious, extracurricular. It doesn't have to be. There's lots of folks who aren't religious at all. Okay, fine. That could also be. And frankly, the courts don't mess around with that. If someone's mom's Jehovah, his dad is Muslim, as long as you don't interfere with each other, the court will not mess with that. Not day-to-day decisions, not emergencies. Tell my client, if your kid is playing in my cul-de-sac and breaks his leg, I'm driving to the emergency. I'm telling you about it. I'm making that. So this is hard. Courts would prefer both parents be involved. They would prefer that both parents have joint legal custody. It's an unwritten preference. And every year the legislature talks about, should we make that a rebuttable? But in order for it to be sole legal custody, the one person makes the decision. And that's very rare, well under 2%. You have to, you or the other side has to actively obstruct decisions to the detriment of the child. Just being a jerk and not listening and not taking his or her, that's called marriage. So, okay, but if decisions are being made, fine. Or if you look at like, where do they go to school? Is that good? You're gonna contest that? Does she contest it? Okay. Where, what doctor? Pediatrician? Fine. What are you arguing about? Leave it alone. It's not worth the money. It's not worth our time. Certainly not worth our time when we're doing pro bono and low bono. Because it's gonna be what it's gonna be, unless you can point to very specific things that happen, and it's definitely one side or the other side's fault, and it's usually not definitely the other side. You communicate, she actually asked you to respond, and you chose not to, and you thought you did, but you didn't hit send, then that's just innocent. Tiebreaker is officially aspect of it's sort of, I even defended an appeal. I know you do. You know Steve Kaplan? Right, really good in court, really smart guy. Too smart, so it makes him dangerous. So he appealed the tiebreaker, went to the Court of Special Appeal, and he said, it's not actually joint legal custody. He gets to make all the decisions, you know? And the judges just look at him. I remember Judge Berger, who used to be here, said, aren't you on the wrong floor? Wasn't that already decided 2 floors up? Nothing you can do. I just got up and I said, you're absolutely right. But in reality, it's not. So in reality, good mediators like Wendy will do things like, how about you have the tiebreaker on medical, but only after you do this. You have the tiebreaker on education, but we'll start with the basis of pediatrician will remain the same, schools remain the same. We'll put in things in the agreement to make it palatable. We shouldn't be fighting about the same. More importantly, the custody battle. Where do the kids lay their head at night? Because only overnights count. Now that, in my opinion, is wrong, but that's the legislature. The marker for shared custody has moved. Now 25% of overnights. The legislature didn't really pick the percentage and stuck us with the math. So 2 overnights a week. Actually, remember, it's also 8 overnights a month, which doesn't help because there's school. So basically 2 overnights a week, unless you do an odd. Most of us do a schedule that makes sense, because the kids should also know it, at least after their point that they get it. Could be 3. So you got your bi-weekly rotation. That's the main. That's why we talk about. We used to say 5 out of 14 is shared custody. Now it's 4 out of 14. Summer is different because school, unless. And then holidays. You don't have to celebrate. That's some Jehovah's Witnesses. But they have their own a couple of celebrations that they do. So that's how you usually break it down. If I don't think I'm missing something, holidays you can define broadly. We'll try to rein them in, want their own birthday to be in the schedule. Or you're going to see them sometime that week, and then the kid's birthday. I want them for part of the joy. One of the only benefits of being a child of divorced parents is you get 2 birthdays. You get 2 birthdays. Or you can, if your client on the other side thinks it's a good idea to share all holidays. Yeah, like I really want to see you and your new man and little Johnny's birthday. Really glad it worked out. So schedules are different depending on the age. So there's a handout about different kinds of schedules. There's one handout that's all different kinds of 50. but it should make sense to the kid. So the kid knows what he, she is going after school. Also should make sense to you in your busy life, so I know, oh, well, I have Mondays. So I'm the Girl Scout dad. Monday's a Girl Scout. So, any questions about schedules?
Thinking of parenting plan, yeah, when you file for custody, you're supposed to do a parenting plan. And like, I'm not good at sort of thinking out the whole year. Yeah, it's really helpful if it's laid out and be very clear.
So, correct, I don't know the answer. I only filed a parenting plan right before the settlement conference. I don't think you have to file it when you file. And the reason why I wouldn't, because everything's raw. You're the mother, and you don't want to write SOB to see the kids at all. So you might write that down. That's, but I hear you. Yeah, and once you talk through, once you help your client do that. Hopefully it's only one school system. Definitely get that calendar. If it's private school, get that calendar. And the other parent, your client lives far away, look for all those 3-day and 4-day weekends and snatch them up, even if that's the only time. What I mean by snatch them up is if you can't do like a regular schedule, look for times where the child can spend time with the other parent. Kids need both parents. That's just, even if your client thinks she is a complete B and shouldn't be around the kids, because that's not how the kids see it. Not at all. No. Both parents should be held up, lionized, vilified. So, I don't know if you have any questions about custody. It's really deep water and everything. Here's one thing, facts change on the ground. So I said PL is probably what will happen in marriage. Yes, unless someone does something crazy and against the best interest of the children, that's substantial. But your client does have to hold his or her nose a little bit. And they also need to. Next slide. Right. So what I'm saying here is your client has works. They won't tell you. They won't even tell you something like their work schedule. Like, oh, I get to work from home. Okay. Well, ask a lot of questions because it might be one day every 2 weeks. Or when you work from home, what does that look like? I mean, I told you a story about, I tried to work from home while I was in law school with our daughter. Started knocking on the doors of neighbors. You know, maybe she won't stop crying because I have a property. So what is it really going on? You have to know. And make it a safe space for them. But you have to know what's up with you. The more you know, then you probably reach yourself.
For custody cases, PL hearing, does it depend on the jurisdiction as far as what is here? Like legal custody or something? Is that something that's not handled in PL hearings? Is that across the board or?
Should not depend. Notice how I said that. It should not depend what issues they hear. You have to plead it. So when you're settling, as you're trying to settle waters, it's usually custody, legal, and physical, which also means access. Usually child support. Use and possession of the family home. Who's going to live there? Maybe alimony if it's an alimony case. Maybe attorney's fees if it's an attorney case. Attorney fee case. People live together. So they do law. Very rare that the magistrate recommends to the judge that one of you leave, which is troublesome, which is why I'm saying this cadence and this one of you should be. So there's that. Now something awful is happening. If it's really awful, they would file a petition for protection. But the magistrate does have the ability to recommend that. Then it goes to the judge, and then might be asking for an exception. When I used to teach, I would say, here's a little extra, it won't be on the test, remember it or not, doesn't matter. When you, before a magistrate, something is really important, it must be settled right then and there, you ask for an immediate order. And this is a little counterintuitive. An immediate order, the magistrate will recommend, here's my recommendation. Won't go to judgment for 10 days. unless the magistrate recommends an immediate order. Then, magistrate says, okay, Judge Smith can hear you at 4:30 today. Judge Jones can hear you at 8:30 tomorrow morning. When are you free? You're going before the judge on, you can agree to immediate order, but one of you can oppose it. Then you go to a judge who's looking at the recommendations and is thinking, this magistrate thinks this is so bad, it has to be an immediate order. And why do you oppose it? Sorry, thanks. You? Okay, good, yeah. I'm signing it, because it must be bad for it to be an immediate order, but you still, the counterintuitive part is, you still can take exceptions. Days, because it was only, it's still a temporary order. So I started talking about that, backing up Kate to, and a magistrate recommend one of you. If she can, and it's rare, it's pretty extreme. Usually when cases come to magistrate, well, in the old days before the change in law, someone was already not living there, so it was easier. Does that sound right? Oh, yeah.
Yeah.
I mean,
Yes.
and the funny part about text messages is your client thinks it makes him or the other side look like a a-hole. And half the time, it's opposite. You're like, I don't read it that way. You should not write this. What do you mean? Let me read it in the voice you think it's, and then I'll read it to you how I read it. So maybe just don't show your butt in your text message. Don't show what a jerk you are in text message. You know, and don't change the name of your soon-to-be ex-wife on your phone. So I was in court in Carroll County, and this guy was lighting my lady up about the things she writes in text. He's correct. Well, I was representing her, but even when I did, she couldn't slow her roll. And then I showed him a screenshot of when the phone, you know, the top has her face, C-U-N-T. Really, dude? So every time she calls you or your children are with you, that's what comes up?
Yike.
Okay.
So you always want both sides of the same set of text messages, because it only shows the picture. Divorce attorney 101.
Or they'll have like some really interesting music, which is really usually not that bad. That good music, but like it's like a song called Darth Vader. So it's like the Darth Vader theme song. That's kind of fun. But I mean, pages and pages and hundreds of pages of text. And you're gonna want to give it to the judge. Did Magistrate Tipton like reading text messages?
Yeah.
Okay. For
Not with
personal
background.
amusement, perhaps, but I mean, like as a jurist. that was-
Yeah.
Okay,
From the law, especially like you said, the
okay.
information.
But make sure it tells the story you wanted to tell. And you're gonna leave some out. They're gonna be like, oh, objection. Weakness. Okay. So I thought this would be helpful. Sorry for the, the Christian bent. I just, that's, I don't know if there's like, those ones, I don't think there are tablets. So anyway, some things you shouldn't do. And I added a handout called Divorce Rules for Parents, because when I'm a BIA, I always give this to the parents, tell them to be on their best behavior, put it on the refrigerator, etc. And it has these rules, among other things. There's also a handout about don't show your worst self on social media, because that will be exhibits. Maybe you deserve it. I'm not going to read a slide to you because I know you haven't, but these are the cardinal sins of custom. You just can't do it. And you're going to pay for it over and over. The other side will burn your butt on this over and over again. Just keep bringing it up because you shouldn't do it. It makes children feel awful. That's why I provided that one drawing from one of the actual cases where he did horrible drawing about. feel like we're-
Oh, I went backwards. Oops, there you go.
So, this is a big deal to our MVLS clients, and it should be. Both parents must pay for their kids. I don't, it seems like a secret, but some of us in this room know this. Even the custodial parent pays child support. If you print off the child support guidelines, it'll show the total child support, and it'll show the amount that the custodial parent is pitching in. Then the other one is how much the obligor parent pays. And anyone who has kids, even the people who, my clients who don't want to pay child support, they know kids are expensive. But why people don't pay child support blows my mind. And it's the only debt you can go to prison for under the Maryland Constitution. And good. That doesn't happen very quickly. But it is all based on your gross income, not your net. I'm so tired of people being like, oh, we take home. Yeah, because you got this, that, and the third coming out of your paycheck. Some of it, like, it's just for fun. And you have your fantasy football office pool. Some HR person is pulling that out. So anyway, it's based on your gross total income. Bonuses, rents, all of it's like legit income coming. So you have to file a short form. Not really an MVLS thing, but if the combined income is more than $360,000, you're supposed to file a long form. I say that because we don't really do that. But you can. I mean, if you make a lot, sure. What about Montgomery? You can practice a lot. Montgomery didn't know why.
I don't practice.
Oh, they don't require the long, right? Maybe
They
they
just
make like 7 figures.
Do they just extrapolate?
They just like, they'll use a short form, they'll have a testify to it, but unless there's like a
Yeah.
real debate about it.
We extrapolate.
Extrapolate.
Like 600,000, 7.
Exactly.
Extrapolate. It makes sense. Because policy behind child support guidelines is a lot of social scientists did all this research, and this is how much two parents combined income, 100,000, 200,000, 300,000, or 50,000. That's how much they pay on. And Jessica, you shared with me that your child is now in travel soccer. I know what that nut is. That's a lot of money. But if you make enough, then you make those choices. But when I grew up in PG County on free or reduced lunch, I did not pay travel anything. I didn't pay travel anything. So, because you just can't. So, the more you make, the more you spend on your kids. And they get a horseback, right? It's not. Okay, so it is what it is. And I say that because that's a saying when it comes to child. Child support is what it is. Period. It's a rebuttable presumption. Good luck rebutting it, because it's presumed that the amount of money is in the best interest of the child. So that's it.
Can I give a practice pointer there too? And I know Jessica had this recently as well. So even if your people are like, just give me the kid, I don't care, I don't want support, just give me the child, I won't make him pay support. And then you pretend you draft it, oh, that sounds like a good idea, let's put that into a consent order, let's put that into an agreement. You'll get to the magistrate and the magistrate will not sign. They will say no. They will say no. Why am I doing this? That has to be in the best interest of the child. How much does each person make again? And like this happened to me recently, because we try, you still try sometimes. You still try, and magistrate someone, and she said, no, we can't do this. So like go back. And then I had to go jump through all these hoops just to keep ensuring that my client wouldn't get child support, because she really didn't want alcoholic dad like to have visitation. So then we agreed. What ended up happening is we agreed on like baby child support, like a smaller amount, and then dad would do X, Y, and Z on other times. So we were able to settle it, but you can't just walk into court and think, oh, my client gets the kid and like bargain that way. Like the courts are getting more and more strict. And there's a new case. Yeah, Hauser is the new case that supports that too, that you can't.
Well, it's going up on appeal. It's at COSA, it's going up to.
But I think it was right. I think
I
reading
think
the
you're
quoting of Hauser, I think they got it right.
I think you're right too. Yeah, so there's no, I mean, in very limited circumstances, is there what we call a general charge of child support, which is what Wendy is talking about. I mean, sometimes you can get away with it if the guidelines come up with like $100 or less. But I mean.
If it's like an $800 swing, they're no.
Yeah, I mean, when Judge Kramer in Howard County was magistrate, she once insisted that $100 was not a reasonable amount for a general charge, and so we got creative and said, dad would put the money in at $529, and that was like kind of like assuaged her concerns, but the problem is when it's those small amounts of numbers, it sometimes creates a problem between the parents' abilities to co-parent, so you really have to get creative as long as the number is really just not too large. I mean, I would say sometimes 250, depends on who your
Right.
jurist is,
And that's a
really.
big deal for him.
Yeah.
The party, did a mutual agreement
Mhm.
on their with child support, how does that work? They put up a guideline, you know,
Yes.
they-
Yes, that's right in the statute. So picking up on what they're saying, the law says in the statute that the jurist, the judge, must must show the guideline. And then must make a finding on the record as to why the deviation from the X amount. When the child, which is also in the statute, if we're trying to get this done, the person just won't pay child support. Usually, every time, that's it. The statute says there are some things that are directly for the benefit of the child that can be substituted, but it's a very short list. Mortgage payment, car payment, 529. After that, it probably goes into the guidelines anyway. You pay your basic amount of child support plus what we call below the line expenses, health insurance, extraordinary medical expenses, and work-related daycare, sometimes school expenses. So the guidelines are a shared income model. That means say he and he. Dad number one makes 200, dad number two makes 100. That's $300,000. Dad number two's shared income is 1/3. So when it comes to extraordinary medical expenses or daycare, he needs to pay 1/3.
Yes, just a quick question. So when I generally draft marital settlement agreements, I'm more or less able to get the general charge for the child support portion, right? So are you saying there's a trend against that because the court does not like that?
Actually,
Right
I'm saying it was always the law, and you got away with it, and it was good on you, but
Oh, okay, but
none of the judges I work for.
got
Because
it.
I tell my clients, you, as a grown-ass adults, you can contract whatever you want, except for illegal stuff and anything having to do with the child. Because here's what I mean by that. You can contract whatever you want for the child, and then it's subject to independent review by the judge or magistrate. Make sure it's consistent with the best interest.
Okay, yeah.
And about a month ago, I had to walk into a courtroom, my guy was really generous, and tell the magistrate, and there are certain ways we talk, right? Well, what my client wants is, he's hoping
Yeah.
that the mom will become sober. And he's hoping that because when the children go to visit her in Southwest Virginia, that her mom and her aunts will be there, just this safeguard. And he's hoping that, so that's why he thinks, he's asking Your Honor to let mom have 3 weeks in the summer and every other spring break. And we're hoping that the safeguards will work. Now, with that in mind, I understand that Your Honor has the right, duty, obligation, and authority to accept that or not. What you think is the best interest of the child is all that matters. So obviously, I'm signaling him, like, don't do this. That's ridiculous. He's like, I'm like, so, all I can do is tell you what my client wants and give you the facts surrounding that, whether or not that's good. That came back and said, absolutely not, totally supervised, because that's what it should be. She's a crazy drunk. She was pulled over just a few months before with her other child in a car seat. I mean, he was like, yeah, counsel, just April happened, this, that, and the other. No, those are all facts of the case. Your Honor, you're right. Those are facts of the case, and I'm sure you're going to consider them. You're going to make your own independent judgment. So I'm looking forward to those recommendations. And then, so you can't, if you got away with it, hopefully it's because it was still in the best interest of the child, because the child support amount was minimal, but you're supposed to submit guidelines.
I did.
Was it close to zero?
Yes.
All right.
Yeah, that's why you're.
Okay.
Sometimes they don't. And we have a current magistrate on the bench who used to be a practitioner who often didn't submit it. Then I'd get her stuff for modification. I don't know what to do with that because her name's on it. But, well, the good part is I won't go before. I guess we should go back real quick to modification.
Oh.
People are gonna wanna change their child support to get more, that's fine. But it can't be, there's no rule that says it has to be 3 months, 6 months, or a year. There's no rule, there used to be in the 80s, but there's no rule anymore that says it has to be 5%, 10%, or 20% increase. Good luck with that, but give it some time. And if someone's salary goes way up or way down, or expenses go way up or way down, yeah. But try to work it out always. Send the guidelines over, and maybe it's not a big deal because I had a gentleman come into me and I was like, it's $300 more and you make more and you'll pay me, and we just did a consent, and but that was rare. People fight. Your hand was up and then his went up and you pointed.
Wait, 10%, 5%?
I don't think 5%. I would even.
I think it depends, 5% of $1 million,
Yeah,
is
well,
more than 5% of $50,000.
And run the guidelines both ways, because our clients will fight over this. I think she could make 100. Says she makes 55, she could make 100. Why does it matter? Here's the guidelines, here's the guidelines. It's $105.
The other thing you have to be careful about, I've been doing this 15 years. I think the guidelines have changed 6 times. And so what inevitably happens is they finally brought it current for income, what, 2 years ago now, 2022? But child support goes up. So sometimes if you think it should be a downward modification because the custodial parent is earning more, it ends up being a detriment to your client who is a higher income earning spouse that maybe doesn't have primary or even 50-50 custody because of the guideline change.
Yeah.
They're not subject to the old guidelines. They're subject to the current ones. So you
Same.
have to be careful about that. kind of
Same
stuff.
thing, we go from 2 kids to 1 kid, 3 kids to 2 kids.
Correct.
Oh, my your client's like, oh, my child support's been cut in half. It might even
Absolutely
go
not.
up.
The first child is always the most expensive
So
child.
after pulling daycare out, that's okay, yeah. But it's all calculation. You can get,
Yes, yes, it is.
if you're gonna do this a lot, you gotta buy Sassy Cal. I think it's just 135 people.
Yeah.
$3.99.
But it's the same calculator that the court's gonna use, so if you, I mean, if you have MVLS cases, you're probably okay to go on the DHS website though, because everybody's gonna be combined 360,000, so if you're not gonna take a lot of family law cases in their MVLS, don't pay for 365. And in fact, you can go to a lot of the courthouses and they'll have them on the computers.
Or call your mentor.
Or call your
All
mentor.
of your mentors should
Or
have
call
Sassy
Nancy,
Cal.
I'm guessing Nancy has them, do you have Sassy Cal?
Yes.
So like if somebody only took like one family law case a year, they could call you on the phone or
Yeah,
send you an email.
no problem.
Now, the guidelines go down when the formerly non-custodial parent becomes a shared custodian. Sassy Cal still has a big glitch.
When did they fix
92, and anyway, good luck. But it goes down.
What if the kid turns 18?
Well, then
it?
you,
It depends.
it goes, how many kids from the jump? 1 kid emancipated.
Let's say 3 and then one is 18.
You run it again because you're pulling out. There were 3 kids, and then there's only a few data inputs. That's what I call it. In Sassy Cal. Children, number of overnights, mom's income, dad income, mom, whatever. Health insurance, and then, I don't know, there's daycare. So if you change one data point, it changes the calculation. Literally a calculus problem. In my opinion, if there's only 1 child, and if it's full guideline, it seems to run about 70. Don't quote me on that, because that's not accurate. And it also depends on where you are in the income. If you're way down, you're making minimum wage a little bit more, it adjusts downward, but if you have no extra income. Anyway, gotta put in the guidelines, just, it won't take 2 to several minutes at most. And, yeah, I have lots of folks who, I have 1 case right now, very high income, went from 2 kids to 1 kid. And the agreed upon amount, because they're above guidelines, was really high, like $7,200. For 1 kid, it's $9,800
On the guidelines.
on the guidelines, because we deviated downward to a big chunk of money. Because he also is giving her $8,000 a month. Right, that's a lot. and she works as a teacher, makes 90 something, so good for her, or good for me for doing it, whatever, but now when we go just switch up on the guidelines alone, put in the alimony amount, it's higher.
So always check guidelines first
Yeah, so.
before you file.
The threshold to modify custody or child support is, there has to be a material change in circumstances. Well, what does that mean? I don't know.
Right.
Do you know?
No, I don't, I
Wendy
was
does,
trying
right?
to make that clear, it
Somewhat-
used to be
it's some-
20% in
right,
the
yeah.
80s, that's because there was no guidelines.
Correct.
So like, if child support's $100, now the guidelines say it's 119, too bad for you, 121. So that's not a rule.
I have
Get there, right?
more of a psychology question for the more seasoned practitioners. Why is child support such a contentious issue? Like just over your years, one or two reasons, like why is that something? Is it
She's
because they?
spending on getting her nails done.
Well, I want to break down, of what that child support is used for and how she's spending the money and da.
I saw her on Facebook, she's out of the club.
She
So
bought
where
herself-
I don't know
She
why.
friends.
But it's funny, but
Yeah.
for some people, it's not.
Right.
For some parents, they're like, well, of course I'm gonna pay child support. Why wouldn't I do that? Like, of course I'm gonna spend it. And then other people are like, no way, but they
It's
will.
not the worst of the worst, though. The other component to that is child support is calculated on your gross income.
Yeah.
Before any taxes, before any deductions, that's not the money people get in their bank accounts, right? Like, I mean, you have probably 25 or 35% in deductions before you ever get your pay, right?
Right.
It's really kind of a, like, calculation and a hard pill for people to swallow, because I owe $2,000 a month, even though my paycheck is $12,000 per month, but I only actually get $8,000. Right? Like, that's a huge chunk of somebody's net income. But the problem is they have to make it uniform, right? Not everybody takes retirement out. Not everybody has an FSA. Not everybody has to pay union dues or, bifurcates money to a different bank account or whatever the case may be. Not everybody has uniform deductions. Everybody's in different tax brackets, those sorts of things. So the legislature, when they did guidelines, made it uniform by using the gross numbers. That's not real dollars for anybody. So you do get a lot of the, well, what is she or he spending it on? But the reality is, in this economy, those aren't the dollars I see, right? Like, that's the big number I use.
Yeah, and I get it. I think with family law, it's super simple, right? People are raised by single parents, and like, oh, well, they didn't need that money, or, what that money could be used for, or when your parent does get money from another partner, and they go buy something that's extravagant, something that they don't deserve that. You remember, like, this person's paying for your food every day, paying for rent every day, but people don't really recognize in their mind, like, I could be in a 1-bedroom instead of 2-bedroom. I should be not driving to your school every day. I could save on gas. People don't really think about what goes to spending for a child every single day. They say that one child costs at least $1 million. I think that's a joke. I think it's like at bare minimum that you're spending on your child every year. And the more you have, the more you spend. But I don't think parents actually equate that, apartment, gas, electricity. They take none of that and say, what's for that child? Oh, you be doing that for yourself. But it also goes up because I have a son or I have a daughter. Feeding somebody for children.
If someone really doesn't want to spend it, always the man, say to them, okay, but don't see your kids and pay primary care guidelines. Send one check, that's that. But the money comes in, because if you have them, you'll take them for ice cream and movies, and they want to bring their friend. And then they want to do travel soccer, they want a new phone at age 7. That's just
Or they
what's
leave
up.
every light in the house on. And
Oh,
electricity is
yeah.
half full. Yeah, seriously though,
True.
I mean, that matters. How many of you have kids? My 13-year-old doesn't know what a light switch is.
I just try to throw some stereotypes at them, like, hey, look, you got a teenage son, he's gonna eat everything.
Oh my
You got a
gosh,
teenage daughter,
yes.
she's gonna burn up your electrical bill. I don't know if it's true or not, but it might hit home with them. It's cost what it costs. But the interesting part about shared physical custody is your child support goes down, but your child expenses to yourself goes up. You do not save money with shared physical custody. I think you spend more, and you're supposed to share other expenses. School clothing, field trips, whatever, tutoring, extracurriculars. I mean, these are just to write the check. Now, I know you want to see your kids, so that's great. Good to see them whole bunch that's not on overnight come in. Because they're sleeping, they usually cheap. I know we have a couple, I think we're doing well on time.
We are doing
Actually,
well.
usually we get like really into the weeds on custody and child support, which is fine. I got support here too, so. If there are other, no, I got contempt and then attorney's fees.
I think it's worth mentioning voluntary empowerment. Especially with like, it could be your client who's an MVLS client who's not working. Like what income do you put on the guidelines that could they be working? Why aren't they working?
That's deep water. First of all, if they can work, minimum wage. As I find myself saying to judges all too much. Ronnie, you know why they call it minimum wage? Because it's the minimum. We gotta start there. Yeah. Oh, yeah, that's true. Good point. Okay. All right, but you know, now it's $30,000, which is that. I don't- That sounds like a lot. It's not, as everyone knows. That's really hard because unless there's some very solid evidence of what they used to make very recently, and there's no reason why they can't make it again, just argument, you're gonna just have to persuade. That's why I said, and I'll answer more, but that's why I said do two different guidelines. Here's her at 60,000. Here's her at 100,000. It's only $105. What are you doing? Or you could get a vocational expert, but they're a few $1,000. That's before they test. And they give you a report. I just did one in a case where this guy's really should work. He's a really interesting person. There's all sorts of stuff. We get the report back that he could make 140. Okay. He finally gets a job last month making 153. And, you know, he just wasted that money for that report, but he might not be employed in a couple months anyway. Anyway, you could do it that way, but that's not really something that PBRC is going to want to reimburse you for. I have tried looking at one ads, just overloading the judge with, but it depends on.
Labor and Statistics also have a website.
Yeah, so it can be admissible, but it doesn't carry the day, and you really want to settle these cases anyway. So you try to negotiate it. Then again, not dollar for dollar on child support, so it doesn't make that big of a difference. This is mostly not for MVLS cases. Try to tell our clients to chill out. One guy currently wants to hire a private investigator in Puerto Rico, like follow her around and go through her trash. Like, what do you think's gonna be in the trash? You know, she's got $1 million house. That might not be her income. She said on Facebook she sold her company 7 years ago for $1 million. I mean, I can't even get the word "so" out. That's how little I can. So, you know, imagine what a judge is thinking. So voluntary empowerment is difficult. I've only got one finding of voluntary empowerment. That was pretty big. He was a VP of Black & Decker and decided to move to Ohio and start flipping houses. Fine by me, but we're still going to use your, whatever it is, $380,000 income. Do whatever you want, because that's what potential income is. Put it in there, run the guidelines, it is what it is. Do whatever you want. Did have one guy who wanted to move to Japan and be a monk. Okay, but you know, he was in IT and made $250. So. And the guidelines at $250, and eventually he came around. I'm like, if you really want to be a monk and it's not about material things, and why don't you just give everything to us? Just an idea. I don't know. Voluntary empowerment is difficult because the way the economy is, and they have to, you in discovery have to demand that they show you all their efforts to get a job. Then you look at the Jane and Jono case, and the other ones that come after that. It's all about timing of their decrease in pay, their education, the geography. Living where we live, I've had some people who are nurses. I can't find a job.
No.
During COVID, they were saying.
Nurses were making $300.
That's why you have to maintain your sanity. Am I the crazy one? It's COVID. Like, you're the only people working. So anyway, probably didn't answer your question, but maybe gave you some ideas for questions for later for someone else. Check in with other people. Make sure you're not the crazy one. That's a great question. Comes up all the time. Then there's people who are older. Should they be working? I don't know. I tell people, I don't want to defend you if you're not at least, I don't want to defend your decision to retire. He's 60. I'd rather be 67, 68, definitely 70 when the judges have to retire. But at 61, 59, 62, ain't old anymore.
No,
Pay
it's
some
not.
taxes, buddy. So when it comes, and some of them have minor kids. So like, that's not, we're talking about alimony. So I couldn't go on the next one. So contempt. This seems to be a big one in the MVLS case.
Oh, yeah, big time.
And I wrote and/or motion to enforce if there's why. Because the contempt law has not changed, but it's been reaffirmed and clarified with the case of Brianna C. Contempt really only requires two things. Is there an order that is clear? And if it's an agreement that someone drafted, it might not be, especially if it's pro se folks are just trying to get it done and trying to, with good intention. I'm reading these agreements, I'm like, I don't know what that means. And judges will definitely not know what it means because I'm trying hard. And they don't want you here in the first place. So I don't know what to do with this. So one, is there an order that's clear enough that the other person can follow, revoke it? And then did they willfully violate? So kids being different nowadays, they're 12, 14, 15, 9. I'm not going to see mom. I'm not doing it. Okay, well, you have to do everything you can within reason to encourage that. Maybe, I don't want to use the word force, maybe, but not if they're older. So they're not, my kid's not coming to see me. How old is she? 14. I'll have a very middle school girl. You didn't want to know that. She's not, doesn't want to go. That's not mom's fault. Maybe you need to work on your relationship, which doesn't make me fun. But, or lots of things, or the obligor parent got hurt, out of work for 6 months, or they're trying to get a job, and they really are, but their interview skills are awful. Their cover emails are awful. They're the same jackass you married in the interview. No one wants to hire him. But if he's trying, tell me that's not true. So if those two things happen, if there's clear order and the other person's willfully not doing it, is there a legitimate defense? And then child support is a little different. The burden shifts over to the person defending it to show that he, let's say T, is paying what he can. So I had a client named Travis. He worked for Papa John's. I don't make any money. That's not true. You make some money. People hate lawyers because they pick on their words. I got one of those Utz plastic pretzel containers, 8 ounce pretzel. Wrote child support on the side. You're going to put this next to your bed, and every time you get tips, you're putting 10% in there. I don't care if it's pennies. You're going to send me a picture every 2 weeks. Take this away. So we did that. Kept doing it, and I sent it to the other side. Here's a photo. He's doing it. When it gets a reasonable amount, let's say it gets halfway up, whatever that is, I'll send it to you. You come pick it up. He ended up getting $777 in that. And that protected him because he was paying what he could. Now, he didn't send it over to him, and that should have happened. But sometimes if you go into court and your client has paid nothing, you're baked. But if he or she has paid 50 here, 100 there, and just keeps doing it with regularity, they're trying, as long as it's a reasonable number, I don't think they'll be found in contempt. Now, Brianna C says, every contempt has to have a purge. If you're a jurist, you say, okay, I find you in contempt, because the order is clear, you willfully violate, there's no legitimate defense, and the purge for your contempt, your violation is you have to pay X amount. Or you have to give makeup time because you withheld the child. But if you're the alleged contender and you purge yourself, even up to the day of hearing, technically you should not be found guilty. So I had one jackass who was also an attorney, not paying the child support, met me outside of Magistrate McCarthy's chambers in Anne Arundel and handed me a check. I just walked away. And he's like, well, I tried to give it to him. I don't have possession of it. Luckily, Magistrate McCarthy is very practical. He's like, well, I'm not holding him in contempt, but I'm making him pay your attorney's fee. You came all the way here. And you did take it from him. You know, I'll take off 20 minutes. What? Take exception, buddy. So, but he did purge. Really obnoxious way. Similarly, if you offer makeup time, so hard to give sanctions if the person purged. On the other hand, if there's an agreement, you file also, you can call it petition. Some jurisdictions like that. That's a different set. That is a violation of your agreement. And it depends what your agreement says. Maybe there are attorney's fees to be had. That's what the agreement says. Next, when we talk about that. And are there any questions about this? Because this is a big deal.
I'm not sure. Is there a difference between civil and criminal contempt?
Yes, and I have no idea what I'm talking about. We're talking about direct civil contempt, and you know, now if someone gets up and cusses out the judge, that's a whole different issue. It's not about the child support or the visitation right. Probably doing some time in the basement lockup.
It's okay. Is it beneficial to file both consent and a motion?
As long as there is a written agreement.
Oh, okay.
So when you go to trial and you come to an agreement and put that agreement on the record, that counts. Hopefully they'll say that in the order. When we write it, it says ordered and agreed, comma, that. And then the first paragraph says parties came before the magistrate on this day, put an agreement on the record in part, and other matters were adjudicated. You want that because then it's a violation of the agreement.
Okay.
Yes, I have a question. As it relates to the makeup time, right? So, you know how clients can be with makeup time. So how much, how detailed would a makeup time be? For example, in a case where she didn't close at close day, do you want to make up the time? And he just never responded. So is that legitimate enough, or does it have to be like, October 27th, I am free. Are you free? I mean, I guess my question is, how do you tell if someone's in earnest or that's not mine? Who cares as long as she said it?
I'm gonna ask if anyone else wants to answer that. I would say it has to be good faith on its face.
Okay.
You want to chime in, Wendy, or is that
You
just?
agree?
I agree.
Okay,
the
all
guessing
right.
up?
Right.
Yeah, like, don't give her
Yeah.
one day, one time. You know she's at her mom's house, or like some crazy time. It's either too late or too early for the kids, and it should be multiple times. You shouldn't do what you did in the first place.
Okay.
So, yeah, and you could even get creative. I'm not saying it's a great idea. Maybe you just say, "Hey, they're with you. How about they stay with you for another day?" And the other person's going to say no, unless they say no because then that looks good. Offered every other week, Sunday overnight into Monday because we're trying to, and then he kept saying no. And you, Jessica, probably heard a few of those with Magistrate Tate, who's now a judge.
Magistrate Tate. I was just
Oh, that's right, of course.
Same thing though. It was
Lauren
hard to
is not
find.
a judge, she would be fantastic. But
Yeah, it's hard to find people in contempt because of free honesty.
Yeah.
Well, 'cause isn't it too, like, the contempt purge provision cannot be makeup time? Right, so like, that's, you're like, okay, you're in contempt, right? Isn't that part of
no,
what free honesty said?
It can be makeup time, it can't be
keep following.
follow the order.
Right, that's right, that's,
Yeah, it can't be follow the order.
like, right. So it
So,
can't
like,
be
if-
like judge wagging their finger.
Yeah.
You're in contempt
That's
because you
right.
didn't follow the order, and now you must follow the order going forward. It has to be a specific
that's right.
purge. And then that's how, you know, and that may get you attorney fees, but it's always awful. Tell my clients, well, you're gonna pay me in hopes that you get 100% attorney fees. So I've been putting in agreements, if there's a violation, it's 110%, might be higher. Because otherwise,
But now I'm thinking of a case through Jessica and I had, I was the BIA, Jessica had, and the mom was awful and withheld the kids for 2 years during COVID, 2 years. So even if Jessica was successful on the contempt, no court was going to give 2 years of makeup time. That would be essentially like flip-flopping custody,
that's
which
not. in the
eventually
children's
happened years
best
later.
interest.
But like it was,
Yeah.
there,
Yeah, because the child decided.
but like
But
even if there is 2 years of like no contact, like the makeup time, like that might just not actually quite be, like you said,
Yeah.
be in the
Frankly,
kid's
you're
best
in
interest.
obligation for that. I mean, that was your best bet because Brianna C is really kind of.
Yeah.
Arguably unhelpful for most people.
It happens less and less, but every once in a while you get a rogue judge. A long time ago, I'm pretty sure this county judge says, well, counsel, are you asking me to change custody? Because I'll do that right now. I'm thinking in my head, you should not do that, but, so, I had to ask my client, who was already on the stand and put on the spot, and he was like, I can't, love to, but I can't. Oh, they have it. Because it's, you know, appealable and wrong, and, but,
I mean, typically the statute says they can if you plead it,
right.
but I
That
don't
would be
think
my
there's enough,
suggestion, Terry.
yeah, I don't think there's enough time in a contempt hearing to make that interest now.
So, with contempt, how would that look like in the discovery phase?
You can't be in contempt unless there's a clear order. So if you filed a motion to compel, and you were given an order to compel, then I suppose you could file petition for contempt. I usually file a motion for sanctions under the 2-43. Guess I could file for contempt.
I think that was not how I understood your
I
question.
didn't understand.
I understood your question to be what would the discovery be in a contempt case? Sorry, maybe
I would
I
do request for-
misunderstood your question.
Was that also,
That's.
I would do request for
Oh,
admission.
you would do both?
I
Maybe
do
should. It
request for
didn't
admission.
occur to me.
No,
Right
no,
now.
you answered the question.
No,
correctly.
maybe I should file petition for contempt. Get a hearing.
If I
45
heard it
days.
like.
So, your question
Must be
more
male,
broadly
female.
is discovery. That's a little bit of deep water, but definitely issue it on time. So scheduling order, scheduling order, scheduling order. And then,
So you have to be really careful with scheduling orders. I get attorneys on this all the time. I practice in counties all over the state. Every scheduling order is different. Literally, every scheduling order is different.
I'll give you.
You must read the words that they say, because some include depositions in their discovery deadline and some do not.
Howard County, here's your discovery deadline, except for deposition.
Correct. Anne Arundel
Usually-
County, here is your discovery deadline, including depositions, which means both records depositions and depositions of a party or a witness that don't require documents. Those are very important things.
With discovery, there's an ongoing obligation.
To
So like,
supplement, yes.
yeah, so in terms of like the supplement, now the case has been recorded for 2 years.
Well, that doesn't happen anymore, but I hear,
Well,
Frederick.
let's say it does.
Is that wishful thinking?
In Frederick,
Baltimore County.
Montgomery
did it.
County it does. because
Baltimore
they
County
have-
it does. I had a case take 5 years.
still?
We filed in 2018, we didn't finish till 23. I mean, COVID was part of it.
Yeah, so in that case, a motion to contempt, a contempt motion or a sanctions motion as it relates to like, what are the taxes for this year? How much money do you make in this one?
So you have to be careful that you asked it in the first place, and that is it truly a supplementation and update, or are you going after the original one? Some judges don't care because they're like, oh, you should have given the 2022 taxes.
I mean, technically producing in full as a supplement, arguably. So I
Right.
think it's a judge issue.
Yeah. And it depends on who's on the other side, because a lot of these attorneys are not very nice, and they'll, get into the whole rigmarole. I had someone in Anne Arundel County contest that she had to supplement. And I preempted that in my motion, like, it's the black letter law, here it is, cut and paste. Judge should know, doesn't do that. He still decided to file an opposition. What are we doing? I'm like, "Oh, what you do, your plan, what you do, you know, sanctions.
Like, I was saying in Anne Arundel County, depositions are part of the discovery deadline. You have to send your records info more than 30 days prior to the discovery deadline. Or a judge will enter an order to quash. So you have to be really careful because they come up, like, Anne Arundel County's come up, that's my practice, but they come up very quickly and they're like 6 or 8 months trial. So you have to be very, very careful, but the other, like, BIA for that is a party to trial. You know, a trial's because you take the scheduling order can't preclude, right? So, and it's like a real way to get around like that documentation issue. And, you know,
Unless they declare it as federal.
yeah.
And if you're practicing domestic in Baltimore City,
Here's it.
they don't process their motions as timely as others.
Who?
Baltimore City, that's the kind way of saying it. So you have to call up and then remind and ask, but don't be too aggressive about it. I used to work there for 3 years. Stuff they say about the folks that come in there with their suits. Because most people are pro se,
The only jurisdiction that doesn't like attorneys.
basically. So I always used to bring Hershey's minutes, but now they're on empty. So there's that. Yeah, so let's do the last slide and then if we can, whatever the time is. So attorney's fees, you have a handout that was generated by a judge in Howard County. It says pretty much the same thing. But there has to be a basis for the fees. Otherwise, we get stuck with the American rule, and some judges love that. Oh, American rule, everyone pays their own. Well, and some judges don't. Some judges are looking for someone to sanction because things didn't go right. So I think there's 2 flavors. There's basically punishment, bad faith, or discovery sanctions, for example. Then your finances don't matter. I've had some attorney's fees awards against some people who don't have a lot of money. Now, good to know because they're not ever going to pay it. You can put a judgment against their house that they're underwater on. You can garnish their paycheck if they hold a job, but then you get behind all these other people too. But that's just reality. We can talk about elections offline. If there's a statute, well, there's a contractual authority built into the agreement. I highly recommend if you're writing agreements, always put that in. And it is what it is. First, the prevailing, whatever the words say, the prevailing party will be compensated. That's what the words say. If it's one of mine and someone agrees to it, and let's say 110%, 125%. That goes both ways though. Oh my client, if you speak to that stuff, you're gonna be sorry that we suggested. But I don't know if a judge will agree to it more than 125%, but it is contracts are contracts. And then comes the statutory cap, which I'm sorry, I call them balancing. It's just balancing test because every single one of these statutes, one for divorce, one for property, one for alimony, one for child asset. This is in the Maryland Family Law Article. Balances the equities. What kind of money does he have? What kind of assets does he have versus her? Doesn't matter. Is it fair? This is the same thing when you're doing a motion for attorney's fees. Whether it's the beginning, middle, or end, because you can ask for attorney's fees at any point in the case. Not saying it'll prevail. They like to say reserved for the merits. I hate those words. We need them now, that's why we ask now. Besides, when you do get an attorney fee award early on in the middle of the case, and again, that's the table and lets the other side know you need to be more cooperative. You need to be more compromising. This is what's going to happen. You're going to get another attorney fee at trial. So there's 3 factors. The third one is somewhat of a throwaway. Is there substantial justification for bringing or defending? Probably. You don't need a lot. Let's say substantial. Everyone is allowed to get divorced. Everyone's allowed to ask them to have their kids for part of the time. And then the other 2, the first 2, as it's written, one factor. The person from whom the attorney's fees are being sought, what does he or she, what are their resources? They have the ability to pay. And does the person who's requesting this, do they need it? And it's not it has to be a pretty big difference. It doesn't have to be huge, but I mean, regular folks. I mean, I got a guy came yesterday, he makes $80,000, and our friend Jack Conlon, nice guy, still asks for attorney's fees. He's not getting it. Folks, he makes $80,000. He pays taxes first and child support second, and then he's got to pay his own bills. I don't think he has any money left. No. I also don't think he's going to hire me because he doesn't have the money to do it either. So I don't know if anyone has questions about how this happens in practice. I think judges don't really like to get involved in that. If there's a big difference, they will. If your client makes adequate money, I don't see that unless the other side really misbehaves.
And I think with MVLS clients, you're less likely to see a client grant a attorney fee that would affect the MVLS client. Is that your experience?
It is. I mean, I've gotten a few, but then the other side is doing some egregious stuff.
Yeah.
Usually it's contempt and not giving any discovery, and so, and that does happen a lot in MVLS cases, especially if you come in and the other side. I mean, you come in while the case is going on, the other side's represented. Because they're kind of bullying.
Mean, yeah.
Bullying the other side, and I'm not saying that attorney necessarily is, but you only get one side of the story. The MVLS client is represented. He or she may not present themselves the best way because they're angry and they don't have counsel to mitigate the presentation. I really enjoy doing the pro bono for lots of reasons. That it's obviously help people who don't have the resources that others do. So I like giving them top-notch rich people service for, and they might not even make minimum wage, but it levels the playing field, and I like doing that as long as the client doesn't ask you to be obnoxious, go too far, which can happen, especially when they're not paying for it. Why don't you file this and that, and can't you depose opposing people? So
I find the pro bono experience extremely rewarding. In fact, I will tell you that in my personal practice, pro bono work was the work that made me the happiest. I just wish more people would do it. I know you fight for that all the time. More people. I'm surprised. We're always surprised at how many. Most of our. Let me put it this way: most of our firms who take pro bono cases are solo firms.
Really?
Yes, the larger firms, not always.
the business manager explaining the ROI. Is not
Right, and I'm not sure about that, why that is. Not all big firms, a lot of our firms, larger firms will take cases, but there's a component of them that don't.
I think it's helpful that you all have decided to do some limited scope cases, because my colleagues who are in big firms say, I'd rather write the check than get one or more of my staff involved in protracted litigation,
Sure.
and the calendaring and the discovery fights,
All of that.
which is where you get training.
It is the way you
get
learn.
better.
You really do learn, you know. And I can remember when I first started out as a volunteer attorney before I was working on this side of the world, there were only about 11 employees working at MVLS. Now we're at 50. So we have grown. When I came on, we probably had about 100 or so volunteer adjudicator attorneys. We now have 180. So we're increasing and we're trying to get more people involved and understanding the importance of it, you know, and the number of people who seek out family law, have family law matters in front of them and don't have the capacity to have a lawyer for whatever reason.
I find it interesting, I think we all know this, but intellectually, but even the more affluent counties have very substantial numbers of people who are not doing very well Financially, they really need help.
Sure.
So, and I know that the jurists, the judges and magistrates appreciate it when we pick up those cases because it's much easier for them. Usually they settle, and most importantly, if there's children involved, children make out better because the parents aren't fighting as much and they're coming up with something.
Oh, sure.
Yeah, but it's very interesting. That's the right word, culture shift. I don't, there's no judgment in that, but even counties like Howard County, the very economically diverse county, you really wouldn't know it. And some of our court staff and the jurists are not as versed, experienced dealing with specific issues that come up in communities that where they don't make as much. And that's not racial at all. That's cross races, but they just,
Yeah.
the judges don't deal with that.
Yeah.
It's often.
Is, I think, I hope this program was helpful. I know, Thomas, thank you for doing this. To do the next two programs. Twist your arm a little bit to do the next two programs. Well, we'll see.
Maybe. Might need like an omelet station.
Yeah. Yeah, but we'll get Sarah to do one of them. What I will do is I promise you, some of you do not have your mentor or mentee here. We've had a couple of illnesses, we've had, things of that nature. I will mail those folders and get you connected again at some point and make sure that those of you who have a case, and a mentor and a mentee, you have a pairing, that you get a case in the next couple of weeks. I think this has been just a wonderful program, and I hope you all enjoyed it. In your packet, I have to tell you, there is one handout, and it's a very last one. It's this 2024 legislative updates, but it says the printer put in divorce law, it should be family law. They followed the pattern of 2023 and put the same title on it. And as MVLS is known, we save money, we use paper, we double side paper. In fact, Thomas wrote to me last night, I was going to print his handouts. And Thomas says, all of these? And when I looked, they were hundreds of pages long. And I thought Susan would fire me if I did that. So they came out by email. Those handouts that Thomas referred to are in your emails. So you will have those to refer to. I will let you know, you have a timeline in the front of what we're doing next week. As I said, in November, we'll assign the cases. There'll be a second training opportunity sometime in January and a third one in March. I haven't decided if they would just be remote or whether in person. I think I'll make them remote through Zoom because the purpose of this first program was to get you all to meet and to mingle and see what it was like and get around other attorneys and get to know us a little bit, get to know me. I'm a remote employee. I live in Ohio. So yeah, I live in Ohio. The magic all comes from afar. And I'm a lifelong, but my daughter had the audacity to have a baby. And of course, I had to raise it. And she is adorable. So I moved to Ohio and Susan invited me to stay. Oh. So I was so grateful for that. So I don't get to see everybody. I don't get to see faces. I see your blurred visions on Zoom, but that's not a good sight. You just don't get to talk to people and see their personalities and their energy and all of that. So I'm grateful to be here. For all of you who don't know, tomorrow night is Celebrate Pro Bono. This is National Pro Bono Month, the month of October. Any of you who are planning to come, I will see you there. Registration is still available if you would like to attend.
you know, it's just been a pleasure for me to be here. Yes, Thomas.
I have to give a shout out to Jessica and her firm. They're getting law office of the year.
Uh,
It might be
Oh,
other
yeah.
than-
And Vincent Mosley is getting an award, but he emailed me last night that he's in the hospital. And I don't think it's anything serious, so he won't be at Celebrate Pro Bono, but we'll make it right for him. You know, but yeah, we have a lot of people in the family law arena that are getting awards. Congratulations, Jeff. All right, Thomas, good job. Loved it. Terrific. What I will be doing is sending out Thomas's PowerPoint, and I will also send you out the presentation, the video. So you'll all get that in a couple of days, and you'll have it for your library.
I really
All right.
appreciate the questions and the folks who chimed in, because that's what makes it better, because I want to make sure that I'm not the crazy one. So thank you to everyone.
Well, we're all a
who
little
understands
crazy because we're lawyers,
that. No,
right?
no, no, yeah.
But, you know, we chose this
Would
profession.
it be possible to also like share folks' names?
Yeah, why don't we have a few minutes? Let's go around the room. I think,
I meant it in a follow-up email, but that works too.
right, well, one thing that I'm always very cautious of is I put all of your names in blind CC because I don't know if you want your emails shared, so you don't get to communicate that way. You're only getting direct ones from me. So let's go around the room.
Before we do that, whoever took video or photos, can you like, give me a couple, only the flattering ones?
Right, right. Yeah, there'll be a survey. So, you know, Thomas likes flattery. So we'll give him some. You want to introduce yourself to the
Sure.
group?
I'm James Ryan. I have a solo practice in Bel Air. I do mainly criminal defense. I also practice in DC.
Wonderful.
Patience Moore. I just started my own practice in Montgomery County, mainly family law and character fitness bar application.
Great. Thomas, you want to say something
No,
or?
I'm next. I'm still Thomas Mulinazzi. I'm in Howard County practice. Almost. Family law exclusively, all things family law, and yeah, and then also Board of Governors, State Bar, and past president of Howard County Bar. So join your bar association so you can build your cohort of people to make sure that you're not